Welcome to the Chief Judge's 2024 hearing on civil legal services. Presiding, the President of the New York State Bar Association, Dominic Napolitano. Presiding Justice of the Appellate Division, First Department, the Honorable Diane Renwick. Presiding Justice of the Appellate Division, Second Department, the Honorable Hector LaSalle. Presiding Justice of the Appellate Division, Third Department, the Honorable Elizabeth Gary. Presiding Justice of the Appellate Division, Fourth Department, the Honorable Gerald Whalen. Appearing remotely is the Chief Administrative Judge of the New York State Unified Court System, the Honorable Joseph Zayas, and the Chief Judge of the State of New York, the Honorable Rowan Wilson. The hearing will now begin.
Please be seated, everyone, and welcome. And good afternoon. There are a few people I should acknowledge, and I want to first thank everyone for attending, both in person and those who are here remotely. And in addition to my colleagues on the bench and President Napolitano, there are a few other people I should mention. Chief Administrative Judge Joseph A. Zayas, who will be appearing remotely and is paying close attention. The Honorable Edwina Richardson, who is the Deputy Chief Administrative Judge for Justice Initiatives and is everywhere in the state, as is the other Deputy Chief Administrative Judge, James Murphy, who is the DCAJ for the courts outside of New York City. The Honorable Kevin Carter, the Administrative Judge for the 8th Judicial District. The Honorable Ann Minahan, Administrative Judge for the 9th Judicial District. Honorable Kathleen Hogan from the Court of Claims. Members of the Commission, we have Helene Barnett, one of the co-chairs. She is appearing remotely today. Same with the Honorable Christina Reba, also a co-chair of the Commission, and the Honorable Shah Ali, the third co-chair of the Commission, who is here in person. Thank you all. Commission members, Camille Sassano-Enders, Christine Fecco, Daniel Hurtow, Janet Sable, and Neil Steinkamp, who's not a Commission member, is a long-serving consultant to the Commission and an invaluable resource to the Commission. Thank you all for your attendance today. From Sullivan & Cromwell, who for many years has provided assistance to the Commission, hosted the meetings, provided all sorts of support, not just technical but substantive as well, and especially to their special counsel and head of pro bono, Jessica Klein, Associate Madeline Jenks, and the two legal assistants who supported this effort, Georgia Macy and Thomas West. From Proskauer, we also had help from Shana Maldonado in putting this together. And the Commission's staff attorney from the Unified Court System, Barbara Moulet, who's organized everything here. Thank you very much. Before we start, I also wanted to specially recognize Helene Barnett, whom I mentioned previously, who has served as chair of the Permanent Commission on Access to Justice since it was created in 2010 by Chief Judge Jonathan Lippman, and who after today's hearing is stepping down as a co-chair, though she will remain a member of the Commission as chair emeritus. Helene has devoted her entire professional career to the provision of civil aid to the poor and in the pursuit of equal access to justice. She began her career at Legal Aid Society of New York in New York City and was there for 37 years, ultimately as the attorney in charge of its civil division. Under her leadership, Legal Aid became the nationally recognized leader in the provision of high-quality civil representation to those who could not afford it, and through such innovations as Legal Aid's homelessness and health law practices. In 2004, she left Legal Aid and was appointed by the President of the United States as the President of the Legal Services Corporation in Washington, D.C. She was the first Legal Aid attorney to hold that position and the first woman to serve in that position. She created what is now a Legal Services Corporation mainstay, the groundbreaking Justice Gap Report, which documents the unmet civil legal needs of low-income Americans. Helene's lifetime commitment to helping the less fortunate among us is exceedingly rare. Two little vignettes, which is hard to pull out two little things that I can tell you in a couple of minutes from a life as long and rich as hers, but two little vignettes might help illuminate how she became the treasure that she is. Helene has recounted that her parents, Harry and Helen Marisman, instilled in their two daughters the moral value of social justice, concern for the less fortunate, and the importance of giving back to society. She said that she and her sister were raised to believe we could do anything that we set our minds to. She enrolled in Cornell at age 16, where she, in her words, was quite popular and had a very busy social life, but told all of her dates, "I'm going to law school, and if they had a problem with that, we shouldn't continue to go out." So, though Helene did not spring fully formed from Zeus's head, it's something pretty close to that. I've had the tremendous pleasure of spending time with Helene and her husband Victor, who has supported her in every conceivable way. So, Helene, I know you're not here in person. I'm sure you're listening. Thank you for your tireless work for the underprivileged. It's inspired and cheered us over many decades. And on behalf of everyone in the room, everyone in the unified court system, and on behalf of the people of New York, thank you for your humble, brilliant, and loving service. So the mission of the unified court system is to deliver equal justice under the law, to achieve the just, fair, and timely resolution of all matters that come before our courts. That goal, however, cannot be achieved simply by having good laws, good judges, and good court employees. Good lawyers are essential. Although indigent criminal defendants are now guaranteed the right to counsel, that became true only after I was born. For most of our country's history, if you were charged with a crime and could not afford a lawyer, you had to represent yourself. When we think about how recently it is, and that's because I think of myself still as young, that our society came to understand that criminal defendants must have a lawyer for our system of justice to operate fairly, it provides a ray of hope that we might realize the same for civil matters that might be equally or more devastating, such as loss of one's home, loss of one's livelihood, or loss of one's savings. According to New York's comptroller, Tom DiNapoli, approximately 14% of New Yorkers live below the poverty level, which is higher than the national average. A quarter of the people in the Bronx live below the poverty level. The poverty level for households led by single mothers is double the average. The poverty level for a family of four in New York is $31,200 a year. Imagine trying to live on New York for a family of four on that income. Now imagine you've received a notice of eviction or an accusation from Child Protective Services that you've neglected your children because they're not dressed warmly in cold weather, or that you've been fired without justification. How do you have the wherewithal to protect your rights? According to the LSC's most recent Justice Gap report, every year, 3/4 of low-income households have at least one civil legal problem. 40% of such households have more than 5 significant civil legal problems. Half of those people say that the civil legal problems substantially hurt their mental health, physical health, safety, relationships, and finances. But only a quarter of the low-income people with significant civil legal problems have even attempted to ask for legal help. And about half of those who do can't find it. Lawyers make a difference. In New York City, low-income tenants who had lawyers were able to remain in their homes 84% of the time. A randomized study reported by the Department of Justice found that unrepresented tenants lost their homes more than half of the time, compared to only 21% of those who were represented. A cost-benefit study conducted for the Legal Services Corporation nearly a decade ago showed that a $6.5 million investment in legal services for low-income New Yorkers generated more than $100 million in savings from the prevention of evictions, another $85 million in cost savings from reduction of domestic violence, and created 5,300 new jobs. We now have a substantial body of research showing that there is a substantial positive return on investment for every dollar we spend on civil legal aid for those unable to afford it. Yet at the same time, legal service providers face extraordinarily difficult times in attracting and retaining lawyers because they are overworked, under-resourced, and cannot pay salaries that are competitive to what the city, state, and local governments pay lawyers. A little more than a century ago, in 1919, Reginald Heber Smith, the director of the Boston Legal Aid Society, wrote a book called Justice and the Poor. In that book, he advocated for the provision of free legal assistance for those who are unable to afford it. I'll read you a short excerpt. A system which created class distinctions, having one law for the rich and another for the poor, we would unhesitatingly condemn as unjust. as devoid of those essentials without which there can be no justice. And yet, the facts, though not the causes which underlie them, are well known. The administration of American justice is not impartial. The rich and the poor do not stand on equality before the law. The traditional method of providing justice has operated to close the doors of the courts to the poor and has caused a gross denial of justice in all parts of the country to millions of persons. Nothing rankles more in the human heart than the feeling of injustice. It produces a sense of helplessness, then bitterness. It is brooded over. It leads directly to contempt for the law, disloyalty to the government, and plants the seeds of anarchy. The conviction grows that law is not justice and challenges the belief that justice is best secured when administered according to law. The poor come to think of American justice as containing only laws that punish and never laws that help. They are against the law because they consider the law against them. Exactly 100 years later, Kenneth Frazier, the chairman and CEO of Merck, wrote, "When one looks objectively at how the system dispenses justice to the poor and disadvantaged, the inequities are obvious. The credibility of the legal system, people's faith in the fairness of the system and its rulings, is critical to its success. And the ongoing health of democracy demands a well-functioning system. The system is not credible when it treats the poor, marginalized, and disadvantaged differently. The rate at which societies fall apart and chaos ensues accelerates exponentially when people have no stake in the social order, or at least believe they do not." Whether you hear today's testimony as stating a moral imperative, an economic imperative, or a socio-political imperative is up to you. Whichever way, it is an imperative, and as I see it, it is all three. In closing, I again want to thank everyone who's here, particularly those who are here to share their stories and experiences and advice. Our work today brings us closer to upending the disparities that Smith wrote about 105 years ago and to creating a reality in which all have equal access to our courts and genuine membership in our democracy. And I'd like to begin this afternoon's program by welcoming our first speaker, Professor Matthew Diller, Professor of Law and Dean Emeritus of Fordham Law School. Professor Diller.
Thank you, Chief Judge Wilson, and thank you, all the distinguished members of the panel. Thank you for giving me an opportunity to speak with you today. I began my career as a staff attorney in the Civil Division of the Legal Aid Society. I had the good fortune to be hired by Helene Barnett a few years ago, and the experience has been critical to my understanding of the legal system, both its shortcomings and its potential. And that understanding has really guided me ever since. When I was at Legal Aid, my clients faced tremendous challenges as they struggled to feed their families and obtain the necessities of life, even while living in a city that contained great opulence and abundance. Time and time again, they dealt with systems that were ostensibly intended to assist them, but in reality failed them in important ways. The systems were often incredibly difficult to navigate and frequently produced erroneous and unjust results. All too often, the court system appeared as simply another impenetrable bureaucracy rather than as a source of justice. I learned the difference that direct legal representation makes in outcomes. The knowledge and perseverance of legal services lawyers has helped tens of thousands of New Yorkers avoid catastrophic outcomes such as loss of housing, custody of children, access to food, appropriate education, and health care. Since my time as a legal aid lawyer 30 years ago, New York has made strides in the provision of access to justice, including expansion of funding for civil legal services and the creation of innovative reforms and programs. These advances have been made possible because of New York's judicial leadership, including your leadership, Chief Judge, which has been steadfast in understanding that in order to administer justice, the courts must play a leadership role in tackling the crisis in access. The court system is not simply a means of processing cases. It plays a vital role in upholding principles of fairness and the rule of law. This role requires its leaders to be proactive in promoting access to justice within our state across a range of dimensions. New York's judiciary has partnered with legal services organizations, the private bar, and its law schools to make real progress and to build a culture of commitment to access to justice across the New York legal community. And yet, so much more needs to be achieved. Despite the expansion of civil legal services and the establishment of New York City's groundbreaking civil right to counsel in eviction cases, thousands of New Yorkers appear unrepresented in New York courts, even on issues of vital importance. Tens of thousands more will never reach the courts, not recognizing that they have legal rights and avenues of redress. I've just completed 15 years of service as dean of two of the great law schools in our state, Fordham Law and Cardozo Law School, and I'm proud of the role that all of New York's law schools play in educating new lawyers about the ways that they can move the needle to bring us closer to the goal of equal access to justice under law. New York's law schools are national leaders in clinical education, which provides hands-on experience to students in representing underserved clients and communities. Our schools have taken advantage of the Pro Bono Scholars Program developed by the Court of Appeals to enable students to spend their final semester in full-time access to justice work and to gain bar admission early so that they can hit the ground running upon graduation. Law schools are also active partners with the justice community in New York in promoting innovative and pioneering approaches to addressing issues of access. Let me underscore, our students have a passion for justice, and in these troubled times, they are a beacon of hope, filled with energy and creativity and a passion for justice. It's critically important that we address the challenges in achieving access to justice for all New Yorkers with a multi-pronged approach. There's no simple magic bullet. Yes, more resources are desperately needed, but it's not simply a matter of resources. We also must be creative and practical in approaching this crisis. Access to justice can only be achieved by rethinking systems to forestall unnecessary disputes, by expanding the role public institutions play in helping individuals navigate complex legal systems and processes, by increasing the range of professionals empowered to assist those in need with advice and support, and yes, through the robust provision of legal counsel. Let's start with the last point. Stable and increased funding for legal representation is critical, and the establishment of a statewide right to counsel in eviction proceedings must be a top priority. Our law schools are producing a new generation of smart and passionate advocates for justice, and legal services funding enables us to draw on this new generation of advocates. Similarly, we must continue to support and cultivate pro bono work by members of the private bar. New York's bar associations are national leaders in mobilizing the bar to play a vital role in closing the justice gap. As critical as direct legal representation is, however, studies reveal that access to justice is not attainable through the provision of lawyers alone. First, legal needs studies show that the number of legal problems is astronomical. It is simply not possible to supply a lawyer for every need. Second, the research shows that people often do not seek help from lawyers, but instead turns to persons tied to their local community, in part because they don't perceive their problems as legal in nature, and in part because they turn to people whom they trust and have pre-existing relationships with. Often people in need turn to the other kinds of service providers, including social workers, counselors, and clergy. In recognizing that these service providers can play important roles, we can better define what forms of advice and assistance can be constructive pieces of the puzzle and what roles would not be helpful. Opening up opportunities for qualified allied legal professionals to provide limited legal advice on routine discrete matters is not second-class legal service delivery, but rather it's a smart component of the solution to access to justice. It's time to re-examine our approach to the regulation of unauthorized practice of law to expand the range of service providers available to people in need. We must concentrate on other dimensions as well. Government agencies that deliver services and those that enforce legal rights, such as those of consumers, tenants, workers, and patients, must embrace access to justice as an essential aspect of their mission and rethink their processes to address the barriers that so many New Yorkers face in accessing services, including tangled and incomprehensible rules and procedures and barriers posed by language and disability. Our public institutions need a deep understanding of how they come across to the public they're intended to serve. And I would include the court system on this list as well, for while the judiciary in New York understands this need and its importance, there's still much more work to do. And we must focus on the potential and the challenges of new technologies. New technologies, including AI and remote modes of participation, can enable us to provide critically needed information and support to New Yorkers. Many innovative projects are already underway in our state and across the country. The conferences held by the Permanent Commission on Access to Justice have featured discussions of many of these exciting initiatives. We must be creative and bold in seizing the opportunities that new technologies create, while at the same time be vigilant in protecting vulnerable populations from the new harms that these technologies make possible. As we develop a multi-pronged approach to solving the crisis in access to justice, we must draw on and participate in the growing body of research into what works and what doesn't. A focus on data collection is essential to enabling experts to conduct serious appraisals of new programs so that refinements and adjustments can be made. New York is a national and global leader in the legal profession in terms of its bar, its judiciary, and its law schools. We're a state that is blessed with great resources, and yet so many New Yorkers have tremendous needs. By working creatively on multiple dimensions, we can and must close the justice gap. Before I close, I just want to take a personal moment to offer my own congratulations and thanks to Helene Barnett, who has been a mentor to me for so many years, and I wish you all the best, Helene, and I'm grateful to you. And thank you, Your Honors.
Thank you, Professor Diller. If the panel has questions to the professor, we can take them now. I have one that is actually prompted by my seeing the statewide coordinating judge for family court matters in the back, Judge Richard Rivera, whom I should have acknowledged earlier. My impression, well, sorry, let me start a different way. We have a shortage of lawyers who practice in family court. And I think that erosion was caused because the 18B rate hadn't been adjusted for a long time, and many of the legal services providers haven't been funded properly for a while. What is it, if anything, that the law schools and the courts might be able to do together to interest law students into going to this area? Because I think it's perhaps the most important area of law.
So, so traditionally, I think there's been an assumption that there will always be law students who want all the jobs that are available. In other words, the number of law students is always, was always bigger than the number of jobs, particularly the number of public interest in government jobs. At this point, that's far from clear that that's true, and I think government agencies and public interest agencies need to think about how to interest and how to recruit lawyers early on, the way law firms do. Law firms start early, and I think public interest employers need to do the same. And we on the law school side need to facilitate that and get the message across. It's something I, as dean, worked on and will continue to work on as a professor. And then second, the economics are just very important, which is that the gap in compensation between the private sector and the public sector has just grown from a major gap into a giant chasm. And so that's just a major challenge that needs to be addressed.
In your materials, Professor, you reference a study in Indiana that showed, to my surprise, that, and perhaps it shouldn't be surprising, but that self-represented litigants prefer virtual proceedings, both for ease of access, but also for ease of the difficulties, the challenges of attending. And I just, you didn't comment on that, but I wanted to explore it a bit.
Well, what I would say, what jumped out at me about that study, and it is only one study, but it shows you the potential that research provides in unpacking some of these issues, is that, the convenience everyone thought about and understood, but what I think people had focused on less is the feeling of of discomfort of being in a courtroom in a courthouse, which is so alien to most vulnerable populations, whereas if they could participate remotely, they can do it in a setting that's more familiar, more comfortable, and where that gap between the court officials and counsel and the individual litigant is not magnified, but rather reduced. Everyone's on the same screen. So I think that study is far from definitive, and there are still lots of issues about the digital divide and access to remote proceedings. But nonetheless, it shows that that there are dimensions to these technologies that are fascinating and go beyond what you might see on the surface.
Thank you.
Thank you.
Any other questions? Thank you, Professor Dillon.
Thank you very much.
We will next have the great privilege of hearing from the Honorable Betty Calvo-Torres, who is an acting Supreme Court Justice in the 8th Judicial District and a supervising judge for the town and village courts in Geneseo and Wyoming counties.
Bring this down. Good afternoon, Chief Judge Wilson, Chief Administrative Judge Zayas, Presiding Justices Renwick, Lasalle, Gary, and my PJ, Whalen, and as well, New York State Bar President, Mr. Napolitano. I'm honored to be with you today. I'm honored to be before you today. As a little girl who grew up in Harlem, living in subsidized housing, it was beyond my imagination that someday I would appear before such a distinguished panel to address issues of concern for low-income New Yorkers and vulnerable communities, the very community that I hail from. As I prepared my remarks, I kept having a recurring thought: there but for the grace of God go I. It is not lost on me that but for agencies like some of those you will hear from today, my mother and I would have been evicted. On one of the occasions, we faced the prospect of homelessness. Today, I stand before you as a Court of Claims judge. I sit in the criminal term of Supreme Court in the 8th Judicial District. I am also, as Judge mentioned, a supervising judge of the town and village courts in Genesee and Wyoming counties. I have been a proud upstater, and more specifically, a proud Buffalonian for over 25 years now. Having lived in Binghamton, Rochester, and now Buffalo, I realize that for as different as upstate and downstate may be, we have many things in common. Unfortunately, the struggle of low-income and marginalized communities to access justice is one of our commonalities. As you know, we have about 1,200 town and village courts throughout New York State. The judges that sit on these benches come from all walks of life. Their backgrounds vary greatly, but their commitment to serve and to justice are the same. Conversations with town and village judges makes it clear that they are committed to providing justice to those who elected them. In addition to town and village judges, I've spoken to other stakeholders, including Special Counsel for the 8th Judicial District, professors from UB and Cornell Law Schools, attorneys supervising tenant advocacy practicums at these law schools, and attorneys at Neighborhood Legal Services. The full impact of evictions upstate on low-income and vulnerable communities cannot be fully assessed due to the lack of data from town and village courts. Anecdotally, we know that the numbers were high post-pandemic, and that today, while eviction rates are starting to level out, they are astoundingly high. This lack of data is due to the inconsistent use of the current case management system in the town and village courts. The system currently in place is not cloud-based and it's not intuitive. Knowing that, the immediate solution will seem to appear to be as simple as investing in a data collection system to be used statewide. Whatever system is used is rendered useless unless we have an actual person to enter the information into the system. And this is where the challenge lies. Each town and village court is funded by its locality. We know that the work of the justice courts is no small feat, and in the aggregate, what they do is remarkable. In 2023, the justice courts handled 1.4 million cases, yet most of the jobs in these courts are funded at a part-time level at best. Without an understanding of the crucial role the courts play in the lives of its residents, the local town boards will not make the necessary investment in their local courts. I've admired how this administration has worked tirelessly to rebuild the relationship with the legislature. I submit that a similar effort on OCA's behalf to, in some cases, inform and in other cases remind the local municipalities of the crucial role the courts play would go a long way towards incentivizing the local municipalities to properly fund the justice courts. We can demonstrate our continued commitment to supporting the justice courts by increasing the amount of money allocated to the Justice Courts Assistance Program, JCAP, which will free up monies received from the local municipalities, allowing for increased access to justice through, among other things, increasing court hours or hiring or increasing hours of court personnel, staff, etc. Signage in the local courts is an issue. The smaller town and village courts, by and large, do not have any signage regarding the rights or resources for a person facing eviction. Providing signage for the courts containing a list of resources available to court users during a time of crisis is a quick, easy, and relatively inexpensive way of increasing access to justice on this essential life issue. Doing so in different languages based on the local population would further that goal. Whether they are attorneys or not, we have an obligation to ensure that our judges understand the law they are charged with interpreting and applying. Currently, the Office of Justice Court Support provides a great amount of training to the town and village courts. This is an area where OCA can double down its efforts by offering an increased number of trainings specifically on landlord, tenant, and housing laws, ethics, implicit bias, and procedural fairness. I am assured that the trainings would be welcomed because the judges are committed to getting it right, and it will help them meet their legal and moral obligation to ensure that only legally warranted evictions are granted. These trainings would also allow us to inform judges about diversion efforts and begin setting a culture where the courts are open to exploring alternatives to eviction. On this issue, lastly, I'll submit that the trainings I've referenced be required by all town and village court judges, whether they are trained attorneys or not. In many of the upstate counties, as you know and has already been mentioned, there is a shortage of attorneys to represent litigants during their time of crisis. I'd like to submit 4 solutions for your consideration. First, OCA can help equip and train each court to allow for virtual proceedings. Recurring theme. This is essential in rural areas where many residents do not have access to transportation. Remote appearances also expand access to legal representation and cuts down on the time and expense of an in-person appearance. Second, help center services should be expanded to assist residents facing eviction in the town and village courts. Third, we must continue to tap into the resource that law students are. When you ask any law student why they went to law school, they will answer with some version of wanting to help people. What could be more fulfilling than helping families in the middle of a crisis as they face the prospect of homelessness? Through current existing housing clinics at the UB and Cornell Law School, students have been able to provide free eviction defense and advocacy in 19 upstate counties. They do so through the Western New York Eviction Prevention Program and Legal Services of Central New York. I'm sure that today you'll hear about the funding sources and the need for additional funding, so I will not address that other than to say the court's system support for the continuation of these programs is essential in ensuring access to justice in the rural parts of our state. Lastly, I would suggest the creation of a hub court in each county. Admittedly, the creation of a hub court is quite the undertaking, but the benefits to the residents of every county abound. They include immediate access to court files for providers, consistency and uniformity in how the cases are handled and decided, increased access to the court because of the regular hours of operation. Based on the success in Erie and Monroe County, we know that consolidated parts work. The 8th Judicial District, now under the leadership of Administrative Judge Kevin Carter, has a reputation for implementing successful pilot programs. I know that we're up for the challenge if OCA is. In closing, I'd like to thank you for the opportunity to appear before you today and for your commitment to access to justice for all New Yorkers.
Thank you, Judge Calvo-Torres. Do we have questions?
Good afternoon, Your Honor.
Good afternoon, Mr. Napolitano.
I agree with you that virtual appearances, especially in upstate rural areas, is probably the most vital way to access justice. But I have a question. How do we deal with the bandwidth issue?
That's a great question, and thank you for it. I know that that's an issue for a lot of rural New Yorkers. So if we were to create a hub court, one of the things we could do would be to create kiosks in the local courts, so that instead of having to drive across, let's say, the 8th Judicial District, which is my home, they would be able to drive to their local court and have a kiosk where they'd be able to access the virtual proceeding there. So I think that's one suggestion. And I have to say, frankly, I don't know many people that don't have cell phones nowadays. But I do recognize that that could be an issue, and I would submit that, that a kiosk would be a simple solution to that.
Well, my question really went beyond the issue of the access to the device itself.
Okay,
It went to the question of the bandwidth that is provided in rural areas in order to even access the computer system
right.
itself. You know, I had the honor, I'm going to use that word because it was, to have a conversation with many of the upstate legal service providers a few months back, because I wanted to be educated on how things work upstate, because that's not where I come from. And I did learn an awful lot, and of course, I did know this question that I posed to you, but even more so, in terms of the virtual appearances, I was rather shocked that some of the judges in upstate areas are requiring legal service attorneys to make in-person appearances, where they have to travel from, as you said, from one part of the district to another. It's not like New York City when you could just jump on a train, right? So I don't know how we deal with that as well. I guess that may be an OCA issue to direct judges in perhaps all of the counties to allow attorneys and litigants to appear virtually. I know that the issue downstate is more a question of showing a need for why virtual appearances as opposed to in-person appearances are required. And there are some issues that, people face, medical issues that don't allow them to make in-person appearances, so I understand that. But thank you. Thank you very much.
I understand your point, and I have heard that during my conversations with stakeholders. And that's part of why I had suggested that we equip and train the town and village judges to be able to hold those virtual appearances. I suspect that when there are judges who do not allow for that, it's perhaps because they may not have the ability to get on virtually. But if we as OCA equip them with that ability and train them to do so, I don't see that being a problem. And insofar as folks who live in the rural areas, certainly a kiosk would address that issue as well.
Thank you, Ron.
Thank you.
I didn't really have a question, but I had a little bit of an observation that married an observation of Professor Diller's and yours about kiosks particularly, that I recall that the Permanent Commission for a few years now has supported kiosks in public libraries in Suffolk County, that periodically in the evening hours there are lawyers who volunteer to help people with the kiosks, and sometimes the library staff with technical issues is also able to help. So we can think creatively, not just about kiosks in a court, we can think creatively that the courts could be part of the community in other places where people could have easier access to them.
Absolutely. I agree with you.
And I want to thank the chief for mentioning Suffolk County in such a positive light.
As a former Long Islander, I felt an obligation. Thank you, Judge Calvo-Torres.
Thank you.
We'll next hear from Heidi Dennis, who is the Executive Director of the Rural Law Center.
Good afternoon. Chief Judge Wilson, Justices Gary, Renwick, LaSalle, and Whalen, New York State Bar President Napolitano, and Chief Administrative Judge Zayas. Good afternoon. My name is Heidi Dennis, and I am the Executive Director of the Rural Law Center of New York, located in Plattsburgh. The Rural Law Center is a statewide, not-for-profit legal services program devoted to addressing systemic legal and economic issues that affect low-income New Yorkers who live in our state's 44 rural counties. We also provide extensive civil legal services to those in need, and our legal staff for these services consists of 3 attorneys and 5 paralegals. I'd like to thank Judge Wilson for his leadership and for continuing to offer opportunities for providers and individuals to talk about some of these challenges for low-income rural New Yorkers to have access and navigate through the justice system. Rural New York is a large area with a substantial population. It is as big as 15 of the 50 states that we have. If rural New York was its own state, resources would not be denied simply due to the locations of the populations. Yet in New York, legal and human services in rural counties are sparse, and that sparseness results in unfair encounters with the legal system, and that fosters persistent and generational poverty. The problem faced by rural New Yorkers in accessing justice are compounded by issues that are unique to rural areas. Lack of transportation is a barrier for access to legal as well as other human services. There are virtually no homeless shelters in rural areas. Land contracts are frequently used when people purchase homes, only to find out that the seller may have a mortgage and risk foreclosure. Rural poor are targets for predatory lending and illegal debt collection practices. Illegal evictions take place because lawful eviction procedures are not being followed. Victims of domestic violence live in small communities where privacy is a rare commodity, and therefore a victim fears seeking protective action. The New York State Bar and then Bar President Hank Greenberg created the Task Force on Rural Justice in 2019, and the task force generated a report in 2020. I was lucky to be a part of this task force. They made recommendations in 5 key areas: rural law practice, funding, broadband and technology, law schools and new attorneys, and law and policy. These issues continue to be prominent in the discussions about rural access to justice. Many of the civil legal services we provide derive out of cases in justice courts. These are courts that operate with overwhelmingly few attorneys and even fewer legal service providers. They are overseen by town and village justices, 85% of whom have no formal legal training. Some of our rural counties have no attorney-trained judges. We see firsthand the challenges faced by litigants in these courts and routinely help clients navigate through them. These courts handle serious civil matters involving housing cases that may result in homelessness, family safety issues involving domestic violence, and loss of income. These matters should be handled by attorney-trained judges. Individuals living in cities have that benefit because cities with populations over 20,000 qualify as a city court designation, and the judges must be attorneys. Yet a city court judge and a town and village court judge hear many of the same types of cases. While training is provided to magistrate judges, that training is not a substitute for formal legal training when it comes to such significant issues. It is in this that the town and village court system where rural discrimination comes into play. The consequences of having non-attorney judges are particularly evident in summary proceedings. The provisions of law governing landlord-tenant matters are complex, yet non-attorney judges with insufficient legal training have the authority to decide these types of cases that impact the ability of individuals and their families to remain in their homes. A prime example are provisions of the landlord-tenant law that town justices have interpreted as requiring a respondent to appear with counsel on an adjourned court date. However, no such requirement exists in the law. We advise clients to obtain adjournments so that we can assist them. Our attorneys prepare pleadings, answers, motions, orders to show cause for the respondents to bring with them on their adjourned date, only to have a judge reject them because an attorney is not physically present. Unreasonable interpretations like this cannot be allowed to continue. The prejudice is profound to an individual who has tried to access their local civil legal service office, if there is one, which is already at capacity, and then turning to the Rural Law Center for limited scope representation in order to protect their rights. While training is provided to town and village justices, more routine extensive training is needed on ex parte communications, making a record, and updates on substantive law that can only improve the delivery of justice in these areas. Since there are over 1 million cases heard each year in the justice courts, it is imperative that enhanced training become a greater priority. Half of New York's 44 rural counties do not have physical legal service offices. Those county residents seek assistance from regional offices or helplines. Many times, there are also no attorneys to refer residents to in their home county. With the emergence of remote technology that was relied upon during the pandemic, the courts in many ways became more accessible to the rural poor. While still plagued with lack of internet availability, many were able to access the court system from smartphones. Unfortunately, since the return of in-person court proceedings, remote appearances are often not available or severely limited. These limitations impact our ability to effectively serve rural clients. We offer clients document preparation, consultations, and advocacy, but we cannot commit to make a physical appearance with the client in court. Remote access to these courts would assist us significantly in providing more extensive legal service. If we were able to appear virtually, we could ensure that clients we serve actually have attorney representation. This would fill a huge unmet need for tenants facing eviction by expanding attorney representation to all 44 counties in our state that are rural. Attorneys and staff at civil legal service organizations are some of the most collaborative, innovative, and dedicated individuals in our profession. We work together, refer matters to each other, and try to maximize each other's strengths. We combine our resources to better serve our populations with what we have. We have created coalitions in order to promote advocacy on behalf of civil legal service organizations. The Rural Law Center belongs to the New York Legal Services Coalition. There are approximately 50 member organizations who have joined together in order to support each other and advocate for our programs. We know the art of maximizing our resources, and we are still not able to meet the demand for our services. Additional financial support is critical. Again, thank you for allowing me to testify today.
Thank you.
Ms. Dennis, a couple of things that you've mentioned. Limited scope representation, which was designed to be of assistance. It has been helpful to your organization and others. The efficacy, that development has been of assistance.
Thank you for the question, Justice Gary. Yes, it has been very much of assistance because we provide a lot of our services remotely. We prepare documents and can communicate with clients and just be able to reach out to the court in some instances and to provide information on just one subject. The difficulty is with limited scope representation is that it often is not welcome, and we need to have a greater acceptance and really a push that limited scope representation is available, is appropriate, and definitely would serve the needs of our rural poor.
The other related thing that you addressed was the need for virtual appearances.
Yes.
Can you describe within your region, do they happen at all in the town and village courts, or is there no capability? Where are we now with that?
It is a huge challenge, continues to be a huge challenge. There are instances where we can contact certain offices to try and determine if we can appear virtually. Many surrogate courts have been open to the idea. Town and justice courts have not. And it may in fact be limited ability to access that information themselves. It may be the fear of that technology. But when we are not allowed to make those appearances, there are clients that you have that you just know will not succeed without an attorney next to them. And if we were able to be that person with them, they may keep their home, they may avoid a foreclosure, they may avoid a judgment against them, and it would just allow us to provide so much more.
Good afternoon.
Good
Good
afternoon.
to see you again.
Thank you.
You mentioned having judges tell your clients that unless an attorney is standing there with them, papers that have been prepared by your office and brought by the client are not going to be accepted. Can I assume from that that NYSIF does not exist?
Correct.
So what, if any, push has been made to get NYSIF filings? So to avoid, potentially at least to avoid that type of a scenario?
Thank you for the question. In the town and justice courts, there's just not the capability to have that communication with each of the courts. Many of them don't use technology. And having the client come and bring physical papers with them to court is often the way that we are able to try to put our legal arguments in front of a court. In fact, we will attach the actual sections of law and other information so that it is easier for the justice to access the information. But there is a true need for an electronic component with these town and justice courts. Many of them are held in very rural areas, in fire departments, in town halls, in various rural areas that have very limited capability to even have broadband access in their facilities.
I just want to share something with you. This past April, I believe it was, or it could have been May, the ABA had Lobby Day down in Washington. And I went with my immediate past president, Richard Lewis, and my president-elect, Kathleen Sweet, and others, down to Washington. And Dick was proposing to the legislators that we met, utilizing the report that you mentioned before, that you were on the task force, which was a great report, very educational. I mean, it really opened up a lot of people's eyes to what goes on in upstate region. The possibility of having law student loan forgiveness by having an attorney commit to a 7-year, at a minimum, pilot program where they would come to upstate regions, hang their shingles, practice law for that period of time, and then have their debt forgiven because they've given that much time to those communities. So enhancing both the person's financial burden and at the same time enhancing the ability to have more representation for upstate areas. So just wanted to share that with you.
Thank you. I appreciate that. That was one of the recommendations that came out of that report. And I certainly think in my remarks that I submitted as one of our recommendations as well, to entice attorneys to come back to rural areas and small communities and establish their practices.
There were at least 2 legislators that we met with, I'll leave their names to be anonymous, that felt that it was a worthwhile endeavor on their behalf to bring it to Congress. So let's keep our fingers crossed.
Sounds good. Thank you.
Thank you. Our next presenter is Mohammed Ufaridi, who is the president of the New York City Bar Association.
Chief Judge Wilson, Chief Administrative Judge Zayas, Presiding Justices Gary, Renwick, LaSalle, Whalen, and New York State Bar President, Mr. Napolitano. It is my honor to appear on behalf of the New York City Bar Association to discuss the need for increased funding for civil legal services in our state. I want to begin with some foundation for my testimony. Our Bar Association contains approximately 150 committees, many of which focus their work on substantive areas of the law that impact New York's poorest and vulnerable communities. Equally important, the City Bar's legal services affiliate, the City Bar Justice Center, leverages pro bono assistance from the private bar to provide free legal services that benefit over 25,000 New Yorkers every year. At the outset, I want to highlight the difference that the provision of free legal services can make. In the housing sector, New York City has reduced evictions by 30% and has helped 84% of the represented tenants remain in their homes. In the immigration arena, the provision of free legal services significantly improves the chances of securing legal immigration status. The data show that detained immigrants with representation were nearly 11 times more likely to seek asylum or other relief than those without it. And represented non-detained immigrants were nearly 5 times more likely to obtain relief than those who were unrepresented. The need for civil legal services is increasing as New York moves further away from the pandemic-era aid programs that lifted many of our neediest residents. And I'll provide some data based on our experience. The City Bar Justice Center assisted nearly 26,000 New Yorkers in need in the past year. We closed 6% more cases than the prior year, and we saw 17% more use of our online resources and information. And we had to redouble our community outreach efforts, which resulted in a 168% increase in people assisted through that aspect of our work. But despite increased staffing and increases in staff efficiency, the data of our civil legal services hotline, which is in many ways the way that many needy people are able to access our justice projects, the data show that in recent months, our staff did not have the time or the resources to respond to 8 out of 10 hotline callers. This is a consistent and concerning trend. It is about 33% higher than historical rates, and that is despite the fact that our hotline staffing as well as our staff efficiency has improved. Quite simply, existing resources do not meet the need for growing need for civil legal services. Based on our experience and analysis, there are 3 communities where the need for free civil legal services is the most acute: children and youth, seniors, and migrants. The Chief Judge already spoke earlier about the poverty rate for New Yorkers. The poverty rate among children in New York City is more than double the national average, 25% in New York City versus 12% nationally. This represents a steep increase since the pandemic, when it had dropped to about 15%. The City Bar Justice Center data show that our services for households with children and youth under the age of 25 increased 19% from 2020 to 2023, but we are not able to assist everyone who seeks our help. At the other end of life spectrum, the senior population in New York City, individuals aged 65 plus, increased by about 363,000 from between 2011 and 2021. Unfortunately, poverty rates among New York City seniors also increased, hitting 24% in 2022. The data compiled by the Legal Services Corporation show that over 70% of low-income senior households had at least one legal problem in the past year, and over 91% of that cohort received insufficient or no legal help whatsoever. The data from the City Bar Justice Center hotline show that our services assisting those aged 60 and over have increased steadily each year since 2020. The 2023 caseload is 33% higher than the pre-pandemic case count for hotline services assisting those 60 and over. Again, as with young people, we are unable to assist everyone who seeks our help. With over 200,000 migrants who arrived in New York City in the last 2 years, the legal services provider capacity is at a breaking point. The City Bar Justice Center's immigration caseload has increased 30% from 2019 to 2023, and our caseload 6 months into 2024 is 39% higher over the same time in 2023. We need more resources to meet the critical need of the migrants and ensuring that New York remains a place where immigrants can find a new home and build a new life. The Chief Judge spoke earlier about the return on investment that free legal services provides, and I'll share some anecdotes based on our own experience. Our own experience confirms that civil legal services funding is a good investment. In our most recent fiscal year, the City Bar Justice Center services realized $14.4 million in measurable direct financial benefits for our clients, representing nearly a 300% return on investment relative to our budget, but stemming from under 3% of the total caseloads that we handled. And there are numerous successful matters, for instance, securing asylum, resolving a landlord-tenant dispute or a family law dispute that do not have a quantifiable financial value, but have tremendous value in human rights secured, vindicated, and stresses relieved. Finally, a few words about what concrete increases in funding might accomplish. Despite staffing increases and increased staff efficiency, which I spoke about earlier, the City Bar Justice Center's legal hotline does not have the resources to connect up to 80% of those seeking our assistance. Our analysis shows that just $163,000 in additional annualized funding could result in an additional 2,000 hotline matters being addressed each year. That's about $81.50 per matter. And an additional $1 million could support over 12,000 more legal hotline cases, benefiting roughly 25,000 more New Yorkers in need every year. We can really use additional financial resources, and our work will make a significant difference in the lives of those who we serve. Thank you very much for continuing to assess the need for resources that are necessary to improve access to justice for low-income and vulnerable communities.
Thank you. I'll start with a question. I'm sure others have questions for you as well. But, and I have no bias in favor of New York. I'm a native Californian, not a native New Yorker. But I think of New York as the greatest city in the world, and I've been to a lot of the other big cities in the world, not every one. But when I hear that a quarter of our children in New York City are living below the poverty level, it gives you pause. And it also, I think if you're a layperson and you hear that, the first reaction isn't, oh, they need lawyers. The first reaction is probably they need food, and they need clothing, and they need shelter. And so how do we marry those two things? I mean, do we provide every dollar we can to lawyers? Is that the best way to get the return on investment? Do we need a mix? How do we as lawyers work with the legislators and the executive branch to address human needs that are other than having a lawyer?
I won't pretend to have an answer to that great question. I think that question needs analysis. I think we need to study the issue. But there are a tremendous amount of things that a good lawyer can do in helping alleviate poverty, ensuring that the family is able to access public benefits, ensuring that the family is not evicted from their apartments, and ensuring that the family has access to basic services that many those who are not in poverty have access to. So a lawyer, I think, will go a long way in helping resolve some of those issues, but perhaps not all of them.
Thank you.
There's no further questions. Thank you for your time.
Thank you. We'll next hear from Kristen Brown, who is the president and CEO of the Empire Justice Center.
Thank you so much. Good afternoon. I'm Kristen Brown, and as you noted, I'm president and CEO of Empire Justice Center. We are a statewide, not-for-profit law firm with 7 offices across the state from Rochester to Long Island. I'm also president of the New York Legal Services Coalition, which is the membership association for civil legal aid organizations here in the great state of New York. Thank you all so much for being here. Thank you, Chief Judge, for holding this hearing today. In my comments, I will be focusing on why judiciary civil legal services funding must be increased and why the initial focus must be on addressing the civil legal services community's severe recruitment and retention challenges. While it may seem counterintuitive to focus on current staff rather than expanding services, as I'll show, these steps are absolutely essential to the sustainability of the field and to our progress in closing New York's civil justice gap, which is the difference between civil legal needs of low-income individuals and the resources available to meet those needs. It's important to note, as we have earlier today, that New York is a leader in funding civil legal services, and we're immensely proud of this. And the Chief Judge and the Court of Appeals, the judiciary, are an important part of this. But at the same time, the need remains vast, with the current estimate of what it will cost to close the justice gap at approximately $1 billion. This is an astronomical number, but it's important that we don't let it overwhelm us. When we think about this collective goal, we naturally think about client needs and areas of law where New Yorkers are going unrepresented. We think about how we can represent more people, provide more services, do more. But what we don't often think about, and we don't think about enough, is what do civil legal services providers need to be successful in serving more people? How do we interrupt the vicious cycle of trying to do more with less when it's resulting in attrition, burnout, stress for our employees, and ultimately fewer people being served? Thinking about these questions, I can tell you from my own experience running a civil legal services organization for the past 5 years, that without the active support for thoughtful organizational infrastructure investment, and without aligning compensation with the systems we work within, New York's efforts at closing the justice gap will falter. We're already faltering, and we need your help. I can also tell you that the data bears out my own experience. I'm going to touch on 3 studies, but there's a lot more information in my written testimony. First of all, at the national level, the American Bar Association's 2023 profile of the legal profession noted a shortage of civil legal aid lawyers, stating that civil legal aid lawyers are among the lowest paid attorneys in the nation, and identifying low salary as one of the primary drivers of the shortage. Second, the New York Legal Services Coalition's 2024 survey of members identified the need for pay parity with government attorneys as a top priority. The survey found that experienced civil legal services attorneys are paid 62% less than their counterparts in the Attorney General's office in some parts of the state. Third, a recent survey of judiciary civil legal services grantees by the Permanent Commission brought these issues into light in a new way. The survey clearly showed that civil legal services providers are losing attorneys to the public sector, to positions in the public sector at an alarming rate because of salary and because of pensions. The data was stark. Outside of New York City, an average of 42% of our attorneys left for government jobs. We are acting as a training ground for government. In New York City, that percentage was a little bit better at 25%. While salary was mentioned as the primary reason for departures, the public pension was also, of course, a major factor. At my own agency, within a 1-month period this summer, 3 of our long-term attorneys resigned to take jobs as administrative law judges at a state agency. All 3 loved their jobs, but with a significant higher salary, with the state pension, economics had to drive their decision. And to give you a sense of what this looks like, for my organization, our starting a salary for attorneys is $57,000. That's the national average. The Attorney General's office starting salary is in the low 80,000s. The survey also looked at vacancy rate, which is the percentage of positions that remain unfilled, and we also looked at how long they remained unfilled. Vacancies impact staff morale, workload, and the ability to serve clients, as well as our organizational ability to draw down funds because most of our contracts are reimbursable. We found that the statewide vacancy rate averaged 13%. This is a consistent rate, upstate, downstate, New York City, the whole state, about 13%. So that means that at any given time, there are approximately, based on our calculations, 426 vacant attorney positions across the state. If we assume that each of those attorneys can handle 120 cases per year per attorney, we can estimate that there are approximately 50,000 people who are not served every year due to the inability to fill these vacant positions. To look at it from a more positive light, if we address the factors that make it difficult to fill the positions, most notably compensation, and we're able to drop the vacancy rate from 13% to 5%, which is the standard rate, we can serve approximately 30,000 more clients annually. In addition to investments in compensation, the survey identified the need for more infrastructure across the sector, underscoring the importance of all of our funders supporting investment in the business functions that help organizations to run efficiently and effectively. IT, HR, accounting, all these things are critical to an effectively running organization. In conclusion, as we move forward together, our collective goal must be to get to a place where civil legal services provide a viable, lifelong career for those who choose it, just like a career in the public sector. Let's work together to ensure that mid-career attorneys do not question whether they can afford to stay in the job that they love and also pay for college for their children. Let's build towards a system where our staff are confident in their ability to retire when they're ready to do so, just like their counterparts in government. To attain this goal, I ask that you take steps to increase judiciary civil legal services funding by at least $20 million annually so that we can reach a baseline for salaries in civil legal services that's consistent with other government-funded attorney systems. And also create a sustainable infrastructure that will support expansion of services so that we're able to move forward steadily to narrow the justice gap over time. Thank you so much for your ongoing commitment to civil legal services and for your time and attention today. I'm happy to take any questions you may have.
Thank you. Are you willing to take a rant instead of a question? I'll try to make it as civil a rant as I can. So I've spoken with many providers around the state, and the message that you've delivered is exactly what they tell me. They're unable to hire young people. They're unable to retain the existing people they have. And it isn't because a first-year associate at a Manhattan law firm can make more than the chief judge of the Court of Appeals. It isn't because of that. And look, I've had both jobs, and this is a better job. And when I think about my own law clerks, and I turn them over every year, they're usually pretty young people. Many of them want to go into public service or government service. That's the choice they're making. They're not choosing some high-paying job on Wall Street. But the gap you described is what winds up with some of them being at Corp Counsel's office or at the Attorney General's office or in other governmental positions because of exactly the two factors you mentioned. And when Judge Zayas and I and others have gone to the legislators and said, just to give you a small example, family court is a priority, the response is, great, we'll get you more family court judges, which they did, and we're grateful for, but the message we keep delivering is that doesn't do any good unless we have lawyers in family court. And this attrition and inability to retain people means we're not going to have lawyers. You can add judges if you want, you can add court personnel if you want, but without the lawyers to serve that population, you're not really doing any good. So in my view, this is really the highest short-term priority. Harder things are, how do you get people to move to rural areas? How do you get town and village justices to be lawyers when there aren't any lawyers in a county? Those are longer-term problems that need solutions, but this is something that can be addressed and really has to be addressed now. Otherwise, as you said, this is sort of existential.
I absolutely agree. Thank you so much for your remarks. I don't know that there's much more I can add to what you said. You really made the point, and you made the point when you delivered your opening remarks as well. Our system is really failing our entire society if we're not able to make advances towards ensuring that there's a level playing field and that the law is applied the same way regardless of your economics. So I think there are innovative ways that we can move forward. You'll hear from colleagues today about those, but I do agree that, if we're not able to fill positions, if we're not able to hire attorneys to represent people, our system is at a loss.
I mean, of course, we should pursue innovative ways, new technologies and so on, but we can't let people think that is a solution, right? It's helpful, it can be Band-Aids in the short run, but it's not a solution. Absolutely.
Just quickly, I just initially want to take a moment. He's too humble to take the credit for this. There's a reality, though, here in New York State. And this court system is a leader by far across the nation in providing money and resources
Absolutely.
to civil legal services. And we dwarf in New York State what any other state in the union does. I would argue, I don't have the numbers in front of me, but I'm willing to bet we probably provide more money as an institution than everybody else combined in the nation, as far as state's concerned. So and that's still a drop in the bucket. I mean, I've heard $1 billion to correct the shortfall. And so my question for you is this. The Constitution is pretty clear about who handles money in the state. It's not the judiciary. I'm curious, what do you hear from our friends across the street when you bring these legitimate, consequential concerns to them? And what explains their failure to respond adequately to this crisis, as you've pointed out today?
Thank you so much for the question. It's a very, very good question. I will note that before the judiciary came in and really, in a really remarkable way, invested in civil legal services, starting with Chief Judge Lippman and to today, the state legislature was our only government funding source and were incredibly supportive for many, many years. We do receive funding from multiple state agencies for specific types of services, immigration services, access to federal disability benefits, the Disability Advocacy Program, foreclosure prevention. There are other very specific funding sources that are at play and taken into account when we talk about that $1 billion number necessary. But when it comes to general civil legal services funding to respond to what's happening across the state, it's really IOLA and the Judiciary Civil Legal Services funding. I think that we can do a better job, our community can do a better job engaging with the executive on general civil legal services funding. I think there's an opportunity for all three branches of government to come together to recognize this, as you noted, Chief Judge Wilson, this existential crisis, but also the civil justice gap, and provide a three-pronged solution, because it can't just be about the judiciary. It can't be about small individual, not small, significant individual programs and, by issue area after issue area. We need a systemic solution, and we need an integrated, all-hands-on-deck solution.
Thank you. Yep, thank you very much.
Thank you so much.
We will next hear from Adrienne Holder, who is the attorney in charge of the civil practice at the Legal Aid Society of New York.
Good afternoon. I'm Adrienne Holder, Chief Attorney of the Civil Practice of the Legal Aid Society, and I also serve as a member of the Permanent Commission on Access to Justice, as a board member for the New York Legal Services Coalition, and I also am on the New York State Bar Association House of Delegates. I first want to thank Chief Judge Wilson and presiding justices Renwick, LaSalle, Gary, and Whalen, and Chief Administrative Judge Zayas, and New York State Bar President Napolitano for the opportunity to address you today. So I have more extensive remarks that you all have. I'm giving you a summary. I have so much to say about everything that has already been said today, but I will stick to my part of the testimony. Investing in civil legal services is crucial for advancing the fight against racism, injustice, and poverty. By providing low-income New Yorkers with access to essential civil legal services, we empower individuals to achieve greater stability and economic opportunity. This, in turn, strengthens families and communities, enhancing both the economic and social fabric of New York City and the state. On behalf of the Legal Aid Society and the broader New York State civil legal services community, I extend our sincere gratitude for your continued investment and support. New York stands out, as you have said, Judge LaSalle, as the first jurisdiction to make a large, sustained commitment and investment in civil legal services. Our experiences have served as a roadmap for other jurisdictions seeking to implement similar investments. Based on years of implementing civil legal services programs and understanding our client community's needs, it's crucial to now turn to the issues of wages, fundamental fairness, funding fairness, and staff recruitment, training, and retention to sustain our legal programming gains as well as best serve our clients. Civil legal services providers face unprecedented staff attrition, reflecting, of course, what you always hear about the Great Resignation affecting both the private and public sectors. However, the need for civil legal services, especially here in New York City, is more urgent than ever. Organizations need to be fully staffed with experienced attorneys and advocates to address those needs. Unfortunately, as you've heard, turnover rates in some offices exceed over 35%, with the loss of seasoned attorneys being particularly damaging. These experienced advocates support vulnerable clients facing critical issues like housing instability, domestic violence, immigration challenges, and when they leave, newer staff are already overburdened. Colleagues must take on their caseloads, leading to delays and added challenges. Recruitment and retention efforts have been hampered by low salaries, significantly lower than comparable government positions. Most departing attorneys, as you've heard, cite inadequate pay as a primary reason for leaving, noting that the cost of living in New York far exceeds what civil legal services salaries can support. And as you also heard, surveys indicate that civil legal services attorneys earn on average 18% less than their counterparts in government, with paralegals and administrative staff earning 15% less. This wage disparity impacts the quality of services for vulnerable populations as attorney positions remain open for months with few qualified candidates. To address these challenges, funding must increase to offer competitive compensation, including retirement benefits, allowing organizations to attract and retain experienced attorneys and ensure stable, consistent representation. Funding must account for more than just attorney costs and must also support necessary staffing for holistic services. Paralegals are essential in our organizations because many of them provide administrative law advocacy and legal support, while social workers address clients' mental health, economic, social, or age-related challenges. Without paralegals, attorneys must take on additional tasks, and without social workers, they handle crisis management without adequate support or training. New civil legal services attorneys must immediately dive into aspects of litigation. There's never a time for them to wait to acquire skills and experience. And that requires extensive supervision to ensure high-quality work. However, attracting and retaining experienced supervisors is a challenge due to insufficient funding for competitive salaries. Most civil legal services providers trail experienced government attorneys' salaries by more than $20,000 annually. Staffing alone isn't enough. Investing in focused strategies to train new attorneys and advocates is essential. These new advocates need a solid foundation to quickly become effective in their roles. Dedicated resources should be committed to creating a comprehensive training institute that leverages the expertise of the legal services provider community. By prioritizing comprehensive training, providers can adjust expectations for newer staff, allowing them to focus on skill development without the immediate pressure of full caseloads. Civil legal services providers face increasing operational costs beyond attorney salaries. Adequate funding must also cover expenses related to occupancy, technology, healthcare, equipment, infrastructure, and support staff. Rising occupancy costs such as rent and utilities strain budgets. Technology and equipment are essential for modern legal practice, but maintaining and upgrading this technology has become a financial burden. Healthcare costs have surged, making it difficult to provide affordable coverage for staff. Without sufficient funding, we may need to cut benefits or reduce the workforce, undermining our ability to retain experienced staff and attract new talent. Support staff are critical to delivering high-quality legal services, yet employing these team members is often overlooked in funding allocations and priorities. We can't stress enough that flat funding is effectively a budget cut, directly impacting client services. Our flat contract budgets fail to account for annual increases in costs like healthcare premiums, utilities, rent, and other operational expenses which continue to rise. On average, space, utilities, and other operating costs increase by up to 3% each year, while healthcare premiums can rise as much as 12%. Yet most of our contracts remain stagnant, forcing us to delay critical investments necessary for effective service delivery. In practical terms, every $100,000 spent on rent increases means eliminating a staff position. For legal services providers, funding adjustments for salary increases, benefits, and operating costs should be centrally covered as they are for government agencies. Recruiting attorneys to work in rural or underserved areas is challenging due to lower salaries, limited exposure to these communities, geographic and social isolation, high caseloads, limited resource, and loan repayment pressures. Offering financial incentives like loan forgiveness programs, salary supplements, mentorship programs, and fostering early exposure to rural legal work through internships can help attract more students to civil legal services to work in these regions. In closing, thank you for your continued commitment to funding civil legal services. We look forward to our continued partnership in ensuring access to justice for all New Yorkers. Ooh, and I would be remiss if I did not take as personal privilege to also thank Helene Barnett, who also hired me, and has always served as a mentor and an inspiration in my development and being able to say that I've been at the Legal Aid Society for my entire career. Helene has always led with excellence and vision and a real commitment to the quality of services that we provide. And as the first and dynamic leader of the Permanent Commission, she has continued to serve as a beacon as to what can be and what should be, and we've been able to implement that with your partnership as well. So I just would like to thank her. Helene, if you're listening, just know I'm extremely grateful, as we all are in this community. Thank you.
Thank you. You have questions from Ms. Holder?
No questions?
No, but let me call out something you said that I don't want to be missed. I think it's important. When we think about provision of legal services, we do need to think about it holistically. That is, the mental health professionals that you have on staff, the paralegals you have on staff, they're important not simply to the representation of people once those people find themselves embroiled in the legal system, but they are people who can serve as future points of contact when some other issue arrives that hasn't yet wound up in court, and they can get advice. And I know that your clients do come back to you and that many times it's not the lawyer, or not just the lawyer, but another person on your staff who provides that point of contact. And I think it's just important to recognize that those people provide a very important role and are part of that. When we talk about the return of investment, that's part of that. That's part of why you have that return of investment.
So my staff would tell you that Adrian always talks about doing the body scan, like doing the body scan of a household. I often say that people come to us by incident of paper. You know, you have an eviction notice, and so you're like, I have a housing matter. But when our folks actually interview and screen the client, sometimes they find out that the reason why they fell behind in their rent is because perhaps they lost a job. And perhaps the reason why they lost their job was actually illegal. And there's something that can happen around that. Our employment law unit can help. Or perhaps they just didn't really understand the best way in which to pursue unemployment insurance. And so we can still help out with that. Perhaps during the course of trying to resolve the case, you find out that there is a mental health challenge in the household. And the social workers can help to connect that person to longer-term services, deal with the immediate crisis, and connect them to other services while our lawyer continues to help out with the work. And as we look for additional income supports to perhaps make sure that that family does not end up in housing court again, as we're doing that, we, of course, have government benefits attorneys and other folks, but looking at the income support, sometimes we've also found like, oh, you have a member in your household is actually eligible for SSI. And so there's all the range of things that our paralegals on the administrative, especially for the benefits access and helping people to apply, there's all the things in terms of dealing with immediate crisis in the household and stabilizing that household, as well as dealing with the issue that they came in with, just thinking that they had a housing court problem because they have an eviction notice, that you're able to do. And our attorneys are able to stave off burnout in that they are able to be lawyers and not necessarily having to figure out ways in which to be mental health professionals and connections as social workers to services, and having to deal in administrative law practice and everything else while they're trying to deal with the matter in housing court. So I thank you for that. And I, too, grew up in Northern and Southern California, and New York City is the best city in the world. I mean, the upstate cities are great. New York State is the best state in the nation, so thank you.
Thank you. We are going to take a recess till 3 o'clock, and we'll resume with presentations made remotely. Please be seated, everyone. In the hope that we can use the technology in the ways that some have suggested we might be able to, we're going to turn to the remote presentations, and we're going to start with Rebecca Sandifer, who's the director and professor at the Sanford School of Social and Family Dynamics at Arizona State University, and a faculty fellow for the American Bar Foundation. Professor, welcome and thank you for joining us.
Thank you. And thank you for the opportunity to be with you today and to share these remarks. By way of introduction, I'm a social science researcher who has spent over 2 decades studying access to civil justice and the role that traditional and non-traditional legal services can play in expanding access and in equalizing it. Today, I'm going to focus my remarks on activities in New York and elsewhere that seek to give people access to justice through working with personnel who are not licensed attorneys. I'm going to describe some of these efforts. I'm going to describe empirical scientific evidence about the safety and effectiveness of some of these efforts. And I'm also going to describe evidence of the capacity of these kinds of programs to scale to meet New York's and America's vast unmet legal need. I will be concise here. Further details are available in my written remarks. New York's access to justice crisis is well known to this court and to the Permanent Commission, and its details need not be rehearsed here. Traditionally, we have relied largely on lawyers to attempt to fill the justice gap. The latest study from the Legal Services Corporation nonetheless found that fully 92% of the civil legal problems of low-income Americans receive no help or inadequate legal help. Lawyers will always be a critical and essential part of making justice accessible, but they are not enough, and fortunately, they are not always necessary. Other safe and effective sources of legal help exist and can be expanded. Let me start with an illustration from New York. In the years leading up to the pandemic, the New York City courts partnered with community organizations to create new programs to help people facing eviction and being sued for debt. That assistance was provided by trained people who were not licensed attorneys. These were the New York City Court Navigator programs. With a colleague, Thomas Clark, from the National Center for State Courts, Tom and I conducted a multi-year, multi-method study of these programs. We discovered that they offered a powerful example of the impactful assistance that people who are not licensed attorneys can provide when people face potentially life-altering justice issues. So in New York City's pioneering project, trained volunteer non-lawyer navigators assisted low-income tenants in the Brooklyn Housing Court by helping them answer landlord petitions for non-payment of rent. We found that litigants who were assisted by these navigators asserted more than twice as many defenses as litigants who did not get any help. And as a result, those litigants that had navigators' help were 87% more likely than those with no help to have their defenses recognized and addressed by the court. That is, the court was more likely to order repair to their apartment or note that they had in fact paid back rent and their landlord should recognize that. Even more encouragingly, one type of navigator who happened to work cases from inception through resolution had a 100% success rate. That is, 0% of the tenants assisted by this particular type of navigator experienced eviction from their homes by a marshal. These navigator roles in the New York City pilot were conducted within the bounds of existing rules about the unauthorized practice of law. The research evidence also supports expanding legal roles further to include giving people who are not licensed attorneys the capability and the authorization to offer legal advice and to engage in forms of representation. I'm going to describe a high-level summary of selected developments in other states and also a high-level summary of the research evidence that supports those states in taking these new steps. Recognizing just how acute is the access to justice crisis and the challenge of existing legal aid and pro bono models to adequately scale, state Supreme Courts in Alaska, Arizona, Utah, and Texas have already granted or are proposing to grant waivers of unauthorized practice of law restrictions that permit justice workers to provide legal services. And these models are described in more detail in my written remarks. The design of each state's model is different, but each reflects a key insight from social scientific research. A key part of justice workers' effectiveness is their capacity to provide actual legal services, including the ability and authorization to give legal advice and to represent people in specific kinds of hearing settings and negotiations. In U.S. jurisdictions, some of this justice work is already permissible and has been for decades, including in tribal courts, in immigration proceedings, in some state tax courts, and across a range of federal benefits. The research evidence suggests that justice worker programs that work have three important qualities that make them effective in bridging the justice gap. They're accessible, they're safe and effective, and they can scale. So the evidence for accessibility comes across a range of fora where these helpers can already assist Americans. And what we see is that when they're available, Americans use them. Americans turn to non-lawyer justice workers in state tax courts, in immigration, in federal benefits, in tribal justice, and in those states that I described earlier where they are already permitted. When they have a choice of getting assistance from a justice worker, many Americans make that choice. So they're accessible. They're also safe and effective. And a range of research demonstrates that the legal work provided by justice workers is, in fact, safe and effective. These are studies that measure the quality of services in a variety of different ways. So some of them look at case outcomes, some look at customer satisfaction, some look at the successful completion of a legal act you're trying to do, so effectuation. Some look at complaints, and some have experts review the legal work product produced by different kinds of legal workers. One of the most rigorous and illuminating studies comes from England and Wales, and it compared non-lawyer justice workers to solicitor providers of legal advice. It looked across a range of civil case types, including benefits, housing, debt, personal injury, immigration, and employment. And it had peer reviewers assess the quality of the services provided by looking at closed case files. An encouraging finding was that both kinds of providers were equally likely to do quality work. Another interesting finding was that justice workers, the non-lawyer justice workers, were 6 times more likely than lawyers to produce work that the reviewers rated as excellent. That is, justice workers can not only perform as well as lawyers, in some instances they can perform better. And that is because they specialize in doing particular kinds of work. They are trained to do specific things, they do them repeatedly, and they become very good at them. If you look at the new models of justice work in the United States, you also see evidence of safety and effectiveness. This is true both in Alaska and in Utah. So Alaska's Community Justice Worker Program currently boasts a 100% client success rate. And in Utah's Legal Services Regulatory Sandbox, where over 75,000 services have been delivered over almost 4 years, there is no evidence of significant consumer harm. It's great to be accessible, it's great to be effective, but even an accessible and effective service cannot solve our massive justice gap if it cannot scale. And there is good evidence that justice worker programs can scale. Unmet legal need in this country is vast, and it's vast in New York State. Justice worker solutions are shown to scale both at home and abroad. So in England and Wales, a range of legal advice providers staffed with justice workers to exist that help people with their civil justice issues. And these include something called Citizens Advice, that it's been around for 70 years. It has offices around the country. You can also access its services by telephone and by internet. And in this service, trained volunteers provide legal advice about a range of civil issues. In a recent year, this service alone, which is only one of England and Wales advice services, assisted over 2.5 million people. In Alaska, implementation of their justice worker program allowed Alaska Legal Services Corporation to substantially increase the number of people served. In the year after implementation, they almost doubled the number of people that they were able to serve, and they further extended their reach to more communities across that vast and rural state, including villages that had no attorney and are completely off the road systems. Utah's Legal Services Regulatory Sandbox, the first of its kind in the world, delivered, as I said a moment ago, over 75,000 services since it opened in 2020. So in summary, a robust and growing body of research evidence demonstrates that justice workers can be an effective and scalable solution, part of the toolkit, in responding to the United States' longstanding crisis of access to justice. New York State stands poised to be a leader in expanding access through expanding legal roles. And the social scientific evidence base provides both support for doing this and insights into how to do it and how to move forward. And I commend the state for starting this exploration, and I thank you for the opportunity to share these remarks.
Thank you, Professor. We have a few questions for you.
Professor, in the various states that you've described in the submissions utilizing the community justice workers, what percentage, roughly speaking, are volunteers, or are more of them just paid but at a lesser rate than lawyers? How does that sort itself out?
So the different models implement justice work in different ways. So in Alaska, some of the justice workers are employees of Alaska Legal Services Corporation, but some of them are employees of other community and social service organizations who are grateful to add on justice work as an additional capability that lets them get their work done. In Utah, there are different kinds of entities that have been authorized to provide innovative legal services. Some of them do that through employees. Some of them do that through upskilling members of government agencies, so that when you come in for certain kinds of help, there's somebody there who can assist you. It just depends on the particular state and the particular model. So there's a diversity of different ways of staffing these kinds of efforts.
I wondered whether you saw any difference between, in effectiveness between the lower paid, group of staff perhaps, or volunteers, as you look across the various means of doing this.
Well, so I would say Alaska, which staffs this in different ways, has a 100% success rate across all the different kinds of staff. But I don't know of a specific study that has looked specifically at the pay that you receive and the quality of service you provide. I do know that lawyers differ dramatically in their pay. I wrote my dissertation on lawyers many years ago and their pay. But I don't know that we think that pay itself is something that changes the quality of legal work. We think more about things like caseloads and the resources that you need to do your work.
Thank you.
Good afternoon, Professor. You mentioned earlier that the use of non-lawyer assistants pass muster with the issue of whether they're practicing law. Correct?
So in in New York's Navigator programs of several years ago, those were within the rules about what you could do in court and what people who are not attorneys could do. In Alaska, in Utah, and Arizona, and now under contemplation in Texas, there are or will be waivers for the unauthorized practice of law that will allow people who are authorized on those programs in different ways to provide legal advice, to appear in certain kinds of fora as representatives.
So the question that I have is, what happens in those instances where you mentioned earlier that there was a great success rate in answers being submitted, defenses being raised more than they would have if the person was there pro se? What if, in that scenario, a case has to go to trial? What if the defenses are, stricken, whether the petitioner, for whatever reason, decides, you know what, I want this case to be tried? What happens?
So that's a great question. Different programs are thinking about different ways to handle that. In Alaska, they follow a model from medicine, where there are many different kinds of, there are phlebotomists and nurse practitioners and physician's assistants, and they operate under a model called standing orders. So part of your training is you learn when you need to hand this off. So there are a range of ways to deal with that issue, that if you're trained to do a specific part of a specific legal problem, you're not going to be trained to do every part of a legal problem. So part of your training needs to include understanding when you need to refer that elsewhere.
But my problem, Professor, is this. To me, this is an access to justice issue for both sides of that fence. So if you get as close as possible to the fence when you have to hand it off, and then there's a delay, right? Because now you have to get someone who has to get up to speed with what that case is about. And to be honest, in my opinion, from what I see, both sides lose in terms of time. So especially in a landlord and tenant proceeding, where delays are there inherently now anyway, especially in the city. And I know you're referencing other states, but I live here and I practice here. So I have to be concerned with what goes on here. I appreciate the fact that in other states, things may be handled differently, but I'm more concerned about how this program is going to be handled here when you find yourself, as I mentioned before, and as you stated, having to hand it off. So.
Well, during the research I did in the Brooklyn housing courts, I spent a lot of time watching people who didn't have attorneys and also attorneys and their staff handle these kinds of justice issues, as you say, on both sides of the issue. And one of the things that you see is attorneys are already working with paralegals all the time who do all kinds of work to get the case to a certain point and then they hand it off. And that's effective because those attorneys and those paralegals have worked out protocols about what kind of information needs to be transferred, about what that attorney needs to know to pick that up at a certain point and take it on. And that's what happens in these other programs. This is a model that we already know how to do, so it's not something that concerns me greatly because we already do it very successfully.
Thank you.
Thank you, Professor. Thanks for joining us.
Thank you for the opportunity to talk with you.
We are next going to hear from Lauren Manning, who is a client of the Legal Aid Society of Northeastern New York. Ms. Manning, good afternoon. Thank you for joining us. Can you hear us okay?
This is Nick Rangel.
Oh,
I'm sorry. Hi.
Yeah.
You are actually very quiet on the bench. It's
all right, hold on a second. And let's see if we can get Ms. Manning on too. Is that any better now? Can you hear better?
yes. Yes, it is.
Ms. Manning, can you hear us?
Yes, I can. Can you hear me?
Yes, perfectly. Thank you. Thank you for joining us. And we'd love to hear from you.
Wonderful.
Nick, are you going first? Am I going first?
Let me just introduce you,
Sure.
Lauren, once. Thank you, Chief Judge Wilson and all for convening this public hearing. My name is Nick Rangel. I'm the Executive Director at the Legal Aid Society for Northeastern New York, LASNY for short. I'm grateful for the opportunity to contribute to this discussion on unmet needs for civil legal services for low-income New Yorkers. Among our areas of expertise, we specialize in family law, homelessness prevention, and public benefits. Many of our issues intertwine with challenges faced by low-income families when children do not receive special education services or are suspended or expelled from school. I'm here to discuss our efforts to address the school-to-prison pipeline through the protection and preservation of the education rights of children. I'm so honored to introduce you to Lauren Manning from the City of Albany. She's been a client of ours for several years, but also a tremendous advocate for the residents of Albany. She previously worked at the Center for Law and Justice, where she helped local residents identify and access assistance and resources, including making referrals to LASNY. Lauren knows firsthand how important it is to have access to legal services when addressing major legal matters and has been a staunch supporter of civil legal services for over a decade. We are grateful to her for agreeing to share her story. Now I'll pass it off to Lauren.
Thank you. Good afternoon, Chief Judge Wilson and the honorable members of the court. My name is Lauren Manning, and I'm a lifelong resident of the City of Albany. Let me begin by expressing my deep appreciation and gratitude for extending me the opportunity to share with you my experiences within the legal aid system in our state. I have utilized the legal aid services. I've utilized the services of the Legal Aid Society of Northeastern New York in many different capacities, including public benefits assistance, housing assistance, eviction prevention, and educational assistance. Today, I will talk about my experiences using their services to help me with educational issues I faced with my daughter, who has a learning disability severe enough to have been classified disabled by the Social Security Administration. I originally found legal aid when my child's IEP, her individualized education program, was not implemented correctly and was not renewed as agreed upon at our special ed committee meeting. I have over 10 years of case management and advocacy experience, and I feel that I'm a good advocate for myself. Even with all of my advocacy experience, I felt like I was hitting the proverbial brick wall, attempting to secure the services my child desperately needed. Legal aid provided me with representation, and their attorneys were able to ensure that my child received all the services she was legally entitled to based on her needs. Using their expert advice, I was empowered to fight for my child's rights for free and appropriate education. During my child's time in remote schooling, I again had to ask legal aid for representation after months of advocating on my own for my child with our home school district. My child was provided with 4 core classes in 4 different school districts in 4 different cities and no IEP support. At this time, the school was also only communicating with her and told her there was no room in science class and she would receive a future notification when there was space. Months later, my child still had not been placed in a science class and was failing math. At that time, I found out that none of my child's teachers were given her IEP or even made aware that my child had a learning disability. I advocated at the superintendent level for my child to be given a science class and a tutor, as she had made it halfway through the school year with no IEP supports, including resource room, and no science class, all things afforded to her under federal law. My trust in the school system as a parent was broken. While dealing with the school district, I felt gaslit. I was forced into an endless maze of different contacts, different answers, excuses, accusations, but no resolution as the school year was continuing to move forward. Again, legal aid provided me with representation. They were able to communicate with the school district's lawyers directly and resolve the issue successfully by getting my child into science class and getting a tutor assigned to my child for 1 hour per day for the remainder of the school year. It's important to highlight that legal aid's advice in the absence of representation has been invaluable to me. I have successfully used their legal advice to win my child's Social Security hearing after she was denied as not learning disabled twice. However, with all my advocacy experience and even with legal information advice, I would not have been able to successfully protect my child's education rights and services without representation. The school system was just too big, with too many departments, leaders, contacts, and too many resources for me to successfully handle on my own. Throughout my years of relying on legal aid legal aid assistance for educational services, their lawyers taught me so much about New York State education law and my child's rights within the special education system that I am even better equipped to advocate for my child and other children in my school district. I also appreciate knowing legal aid remains a resource to me and my child in the future if needed. My daughter was reading at a 3rd grade level entering the 9th grade. Now in the 11th grade, she is reading on level. She is buying books with her own money, and she now has the confidence and ability to do so. I couldn't be prouder of her. Chief Judge Wilson, I know that you and the Court of Appeals are committed in attempting to resolve the obstacles and roadblocks that I have faced. I only ask that you remain committed and vigilant in your leadership roles in addressing these issues so other parents in our state don't face and continue to face the same issues I've experienced. I deeply appreciate your time and listening to me today. Thank you.
Thank you, Ms. Manning, and thank you really for your time and sharing your experience with us. Do we have questions for Ms. Manning? I have two little things I guess I could add. One is I had an experience a little bit like yours many years ago where the public school district we were living in had misinterpreted the age cutoff for speech services. And, I was in practice then, I was not a judge, and I sort of, took it to them and showed their counsel the laws and regulations, and they relented. But my wife and I wondered to ourselves whether they were going to change their policy or whether they simply backed down because we had caught them, but they were going to continue to, there's a substantial population in the district that would have benefited from speech services. I never found out what they did, but it really, for me, emphasizes what you're saying. The other is, if you have any advice about how I can get my 13-year-old to buy books with her own money, I'm all ears. Right now, it's just Roblox.
So my daughter just turned 16 this year, and she had a reader, thank God, because of legal aid services and all these things. So she would listen to books, but she's a big Roblox fan. There's something called manga. They like this sort of Asian anime kind of stuff at that age, and they're huge books, and she loves them. And then, so you just got to find out, what's her thing. And then she was able to work a summer job because of her IEP, was able to give the city's summer job, hey, this would be a good fit for her. So it's actually a program that supports her education that she goes to every summer, rather than being like a camp counselor taking care of kids. So I think it was a combination of all of it. And since you asked, I'd like to mention that I already had to send an email. They had my daughter handwrite a 400-word essay with none of her supports. And as soon as I sent the email, they were calling me at 8 o'clock at night because they know I will call legal aid in on them.
Yeah, my daughter had to read 2 books over the summer reading for her school, and one of them she said, "Oh, Dad, it was really easy. It was a comic book," and he showed me this kind of manga thing that she'd read. And I guess reading is reading, but we figured out that part of it. But thank you.
No problem.
Ms. Rangel, we're up to you.
Thanks very much. Lauren's story demonstrates an example of the many reasons we are particularly concerned with the educational rights of children. Education rights are one part of addressing the school-to-prison pipeline and the disproportionate rate at which BIPOC children and children with disabilities are often involved in disciplinary actions. In too many instances, children with disabilities are referred to law enforcement for misconduct instead of provided with the services they need to thrive. We are addressing this issue by providing legal assistance, community training, advocacy, and representation for students in principals, conferences, or superintendent's hearings when facing disciplinary actions through the Education Law Project. There is substantial evidence students need greater access to legal assistance in conferences and fair hearings to mitigate the negative impact disciplinary actions have on their permanent record. In 2021, the New York State added new funding to provide representation in special education and related discipline cases for children through the Division of Criminal Justice Services, DCJS, for entities across the state. Our allocation from this appropriation was $47,272, which is less than a third of the cost of a full-time attorney. As a result, the Education Law Project is funded by both DCJS and our Judiciary Civil Legal Services funding, JCLS. With this funding, we provide representation, advice, and information to children and their guardians for their rights in the Capital Region. While we are tremendously grateful for the funding we received to start the project, I echo what my colleagues will discuss in this hearing, that civil legal services are woefully underfunded in all categories. Specifically, children who live in rural and remote areas have even less access to appropriate classroom support and special education options. These children also have virtually no access to civil legal services because our Education Law Project funding currently only supports the Capital Region. Expanding the Education Law Project is one of the many opportunities to close the access to justice gap in upstate New York. In addition, I wish to mention a few of the barriers we face in our effort to expand our services across our service area so that we can have more offices closer to where our clients are in our more rural and remote areas of the state. For one, it's incredibly difficult to recruit attorneys. I know you'll hear this theme throughout this hearing, but civil legal service salaries are notoriously below market in all professionals that we employ. Housing costs and inflation rates across the state are notoriously high, and finding attorneys either in or willing to move to more remote service areas is exceptionally challenging. Second, our employee benefits are a strong recruitment tool, but I wish that they could be better. Much of our student loan support, for example, is restricted to attorneys and does little to help other professionals like our accountants and human resources staff. While LASNY pays most of the healthcare premiums for most staff, the cost of our healthcare benefits has increased by 14% in each of the last 2 years, while many grant funding allocations remained flat. Third, it is very difficult to access funding to keep our office space in good working condition. We have tried to ensure that our buildings are on a main bus line, have free parking for clients, are wheelchair accessible and easy to access for the local community. But the cost of space continues to climb, and because most of our program grant restrictions, we must find a separate capital improvement funding to update our buildings so we can stay in those communities where our clients need us the most. Finding that separate funding is difficult and very limited. Finally, there is and kind of remains to be a bias against the administrative cost of running a nonprofit law firm. Many of our program grants cap or prohibit overhead administrative expenditures. Several grants prohibit administrative expenditures, but still require heavy documentation, reporting, and auditing, which we have to pay for from other sources. As a result, organizational infrastructure, such as adequate human resources staff, accounting staff, and operations staff, and other administrative roles, though essential, are often unsupported in grants. Nonetheless, LASNY and all of the other legal service organizations in the state persevere. When Lauren came to LASNY in 2021, her child was going into the 9th grade. The whole world was in the middle of a pandemic crisis. Students and educators struggled with mental health challenges, higher rates of violence, and much lost instructional time. As you heard, Lauren's daughter was reading at a third grade educational level and was at risk of falling even further behind. But instead of telling a story here today of failure or of the lost generation, as they're being called, we're telling a story of hope. Because of our ability to provide civil legal services to protect and defend Lauren's daughter's educational rights, we're here telling a story of resiliency and empowerment. LASNY supports increased funding to civil legal services in ways that allow greater flexibility to meet salary demands, ensure work-life harmony for hardworking people who choose public service, and to both maintain and expand access to the hardest to reach regions of the state. Thank you so much for your time today.
Thank you. You have questions?
I do. Good afternoon, Ms. Rangel. Good to see you again. And
you, Judge.
I noted, and you've just stated, that the Education Law Project is restricted to the capital region. So a couple of things. That means that someone in Clinton or Essex County who needs those services is just told no, I think, and you just can't provide it. And the other question is that because of an administrative decision, or do you have a grant funding that literally said, we are only going to support this location? How does that come to be, and what do you do about it?
So we have sort of combined funding sources to have one full-time employee equivalent here in the Albany office. And that FTE only has the bandwidth and capacity to serve this area. We know that, for example, Albany City schools have a disproportionate rate of suspensions and expulsions for BIPOC students. We just don't have the capacity to add an FTE to those other school district regions. And the travel time to send a person from here to Clinton County makes that a tremendous undertaking. These hearings do tend to be in person. We do try to meet clients in real life, something that is a little bit lost and changed over the course of the last 5 years, but which is very important for building relationships with clients. So I think it's twofold. We don't have enough funding to add additional FTEs to those North Country offices where we do provide other types of services. And the FTE here doesn't have the capacity to expand into additional school districts.
Yeah. And my apologies if it sounded like a criticism. It really was a question. I appreciate that you can't have one person covering that enormous area. But one of the things we've been speaking about is in a lot of contexts today, is expanding virtual appearances. And would that be, I heard you just say that the IEP meetings are in person. Is there an opportunity there for potentially expanding to then and dropping the windshield time, as I've heard it described?
I love that. I haven't heard that, and I'm going to keep it. Yes. So if we were to hire additional attorneys in Albany who served more of our service area, virtual access would allow us to reach other offices. We have 6 offices in 16 counties, which means the majority of the counties we cover do not have an office at all. So even with the option of adding virtual appearances, the closest office for a client to reach is sometimes several hours away from where we are. And so somebody is traveling to a location to ensure that we have the correct paperwork, that we conduct the correct intake, that we process a person's intake appropriately and drop off or make documents available. So even in the case where virtual hearings are available, there are a number of instances where clients need some in-person assistance or support. Maybe they don't have great internet service, so they have to drop off documents. Maybe they don't have a lot of service in the Adirondacks. We all know that service in the Adirondacks is unreliable and scarce. So those individuals still have to go somewhere where they have internet access, a computer, an email address, and some way to get documents to us or to their school district. So there are still barriers to service even when virtual hearings are available.
Yes, Ms. Manning.
I just wanted to add that was actually the cause when the pandemic first hit. My daughter was in 6th grade going into 7th. That was the cause of me having to call legal aid in the first place. They moved the meeting to virtual, and everything I thought we discussed, and they don't record them, was not in the IEP. And I found it to just be a huge barrier to getting to the understanding of what my child needed. And as a parent, I would never prefer a virtual special ed meeting about my child's services over in person, as well as I did have to exchange lots of documents with legal aid. And I am thankful because they're located in my city on a bus line. So I just wanted to add that as a parent who went through a virtual meeting, it was a disaster.
We have heard, we held listening sessions in partnership with IOLA over the summer where we had past and current clients come in and tell us what could we do to improve their access to services. And we thought it would be very clever to create an app where they could upload information and we could track their applications for service. And they were vehemently opposed. Many people who are at the lower income brackets don't have enough minutes on their phones or data limits on their phones. And so when you add lots of meetings and email exchanges and the need for data or internet or minutes, that can deplete the service that they do have, which they try to save for emergencies between their children or between family members.
Chief, PJ LaSalle, and then.
Yeah, go ahead, Chief. Thanks. Counsel, I just had a question. I apologize for my ignorance here. I've heard this term used it twice. I'm assuming it's an acronym, BIPOC. I don't know what that means.
It's Black, Indigenous, and people of color.
So people of color are different from Black, Indigenous? Black, Indigenous, people of color? Or
Yes.
Black, Indigenous, and people of color? I'm just trying to, does it include everybody, or is it just?
It includes everybody who is a person of color, Black, or Indigenous.
Very good. Thank you so much.
Of course.
Oh,
A lot of acronyms in the DEI space.
Thank you. Thank you, Chief. I have a question, and Council Rangel, I think you might be the perfect person to ask this question. If you're right on the front lines of providing these services to people, and we're dealing with the funding that's going into providing these services, and when you're dealing with these success stories, those success stories are by themselves, it seems, a reason to continue providing the funding. But isn't there also, in your line of work and in the front lines of that work, you see where people didn't get the services they needed and fell out of or away from the educational services that they should otherwise be entitled to? And isn't there a cost associated with that in terms of sometimes them finding themselves in trouble with the law or in other circumstances where there's a cost to society that is outside of what we're trying to provide with the funding?
Of course, there are always going to be people who fall through the cracks. I think when I am considering a client and a family, I think of a snapshot. I'm available to assist, for example, Lauren's daughter on one piece of their household puzzle. But if they don't have access to an attorney for their disability claim, or they don't have access to an attorney for their public benefits, then other pieces of that snapshot can kind of fall apart. And those disruptions can cause destabilization in a household, which, as you mentioned, can cause destabilization across the community. And I think that is part of why legal services are so crucial. We can provide almost wraparound services. When somebody comes into our office, we're screening for other legal issues that maybe they don't realize is a legal issue. Most people don't know that they have a right to an attorney to sit with them in an expulsion hearing with their superintendent, right? So they may come in and say, I'm actually here for an eviction, and then we learn their story and we learn, oh, well, you also have these disability benefits that could help bring in income to your household that would help prevent eviction in the future. So, I think you're highlighting the benefit to fully funding and expanding funding for civil legal services, where there are so many people who have no access or little access to the services that we can provide.
Thank you, Counsel.
Of course, thank you.
Before I let you both go, PJ Whalen's comment fits with something that we were all talking about at the break, which is that we need to better get the message out that when we talk about investment, that if you invest in legal services, you can provide benefits to society generally as well as to the individual and save social costs. And I think Ms. Manning's daughter now has a bright future where without your services that wouldn't have happened. The other thing I wanted to say is that I'm sure that the two of you worked incredibly hard to get that result, but we shouldn't forget the person who probably worked the hardest, who's your daughter. So congratulations and our gratitude to her.
Absolutely. And moreover, much of the work we do brings federal money into the state of New York as well. So disability benefits are really owed by the federal government to people who live in the state of New York, and without access to those benefits, the state of New York is paying for a person's cost of living and state level benefits. So there's an additional benefit to civil legal services at the state level as well.
Great. Thank you both very much.
Thanks so much. It's been a pleasure to be here.
Thank you very much. And I don't know if you guys have a minute, but I do have the opposite side that addresses exactly what you're talking about. My two children are very far apart. I have a 27-year-old son. He needed special ed services and things. He was expelled, disproportionately. We all know, like, Albany School District was under receivership by the state attorney general. Always being suspended, always being expelled. For me, expelled once. For example, he was taking car shop vocation and they let him use the screwdriver for a skateboard. That was considered a weapon and he was expelled. I didn't know back then. I was younger and there was not a lot of marketing about legal aid. So I never got him any help. And unfortunately, but I'm not afraid to say this, because I know he was raised right. He is in his 3rd year in state prison. He goes to parole in April and he will get out in June. He had never been arrested before, but he barely made it through high school. I think he was 20 when he finally graduated. And I really chalk it up to if he had received services like my daughter did, I think we would have saw a whole different path for him. So I do want to point that out, that's very relevant of what you guys were speaking of.
Yeah, that's a tremendously important point. Thank you. Thank you again, both.
Thanks so much.
We are next going to hear from Carol Lucas and Lori O'Brien. Carol is a client of Legal Assistance of Western New York, and Lori O'Brien is the Executive Director of Legal Assistance of Western New York. We're just adjusting the screen a tiny bit so we get both Ms. Lucas and Ms. O'Brien on there. I think we've got you both. Can you both hear us?
We can.
Yes.
Great. So I've introduced you, Ms. O'Brien. The floor is yours when you're, I'm sorry, we're going to start with Ms. Lucas, I guess. Is that correct?
Yes, that is.
Okay, let's start with Ms. Lucas.
Okay. Good afternoon, Your Honor, and all others present in the room. I thank you for the opportunity to be here today and allow me to speak about my experience with Legal Aid Western New York. My name is Carol Lucas. Prior to what I'm about to describe to you, my husband Charlie, a disabled veteran, and I lived on our property for 40 years. And before that, the property belonged to my family for a number of years. Before I came to Law New York, we lost our home due to a tax foreclosure. We lived in Woodhull, New York, which is a small town in Steuben County in upstate New York. Charlie had taken an early retirement years ago due to his health beginning to decline. And while tending to Charlie's daily medical needs and doctor's bills and doctor visits, we'd fallen behind in our property taxes. We became overwhelmed by the bills and we were embarrassed to ask our children for help. By this time, Charlie had been hospitalized for 15 days with COVID-19. He was discharged and placed at inpatient rehabilitation to regain strength and mobility, but came home with permanent oxygen. We were told that the highest bidder would take our home after an auction was conducted. The property and farm had been in my family since the 1920s. My grandparents lived there, my parents, and Charlie and I lived and raised our children there. Our home and our house for over 40 years sold at auction for $45,000 to a stranger. To make matters worse, after it sold, the buyer issued us a 10-day notice to vacate the property. I came to Law New York feeling helpless and hopeless. We understood that we needed to move. However, it was difficult to move 40 years worth of possessions with my husband Charlie relying on a walker for mobility among other health issues. During this process, my husband passed away on the 20th of September last year. Law New York negotiated a lengthy adjournment of the case to allow me time to remain in my home and gather more of my possessions and mourn the loss of my husband. Law New York met with me and advocated on my behalf to the buyer's attorney, allowing me more time to move out. I unfortunately was not able to gather all of the 40 years worth of possessions in time to move out. Many items were placed in a dumpster by the new owner of my home. However, I made peace with not wanting to go to small claims court and instead wanted to focus on a new beginning. The new beginning was made possible by Law New York. They filed a motion in Supreme Court against Steuben County and recovered surplus funds from the auction in the amount of $34,264. After a hard, long search, I found permanent and affordable housing that allows me to have my companion and emotional support dog, Phoebe, live with me. I thank Law New York advocates who worked on my case, including Michelle Creamer, Liam O'Halloran-Vesey, and Mark Wattenberg. I truly appreciate all of their help and support during this very difficult time in my life. Do you have any questions for me?
Thank you, Ms. Lucas. And very sorry for your many losses, particularly your husband. And, you know, a farm that's been in your family for 100 years, it's hard for somebody who, like me, who's more of an itinerant, to understand how important that must have been and how much of a loss it must have been. But I feel very badly for you. And, you know, doing the rough math in my head, it seems like you lost your home over what's not a huge amount of money. It's great that you were able to recover most, you know, the sale price, but that's a small consolation, I'm afraid. I don't know if we have questions from the...
No, thanks.
No. Thank you so much. Ms. O'Brien? Ms. O'Brien, we can turn to you. Maybe give us some context.
Thank you, Chief Judge Wilson, distinguished panelists. We appreciate so much the opportunity to share comments related to our work, the work of many civil legal services practitioners, and the challenges faced by our programs as we work towards achieving access to justice. Thank you so much, Ms. Lucas, for sharing your story. So my name is Lori O'Brien. I'm the Executive Director of Legal Assistance Western New York. I've been a civil legal services practitioner for over 17 years. Law New York provides comprehensive civil legal services in 3 judicial districts. Our staff serve a geographical area of 14 counties. 13 of those counties are rural in nature. We serve an area of almost 10,000 square miles. So to put that into perspective, it's larger than the state of New Jersey, the state of Rhode Island, the state of Connecticut. Ms. Lucas's case illustrates the critical importance and stabilizing effect of civil legal services when individuals and families are in crisis. It also demonstrates the opportunity we have to create long-term economic success for our clients and their families by preserving equity. Law New York has long prioritized stopping the loss of equity in tax foreclosures, including through the precedent-setting Second Circuit decisions in Gonzalez versus Ontario County and Hampton versus Ontario County. These cases established a path for homeowners to preserve equity through a bankruptcy claim up to 2 years after the tax foreclosure. Moreover, the U.S. Supreme Court decision in Tyler v. Hennepin in May of 2023 opened up new opportunities to protect homeowners from losing their property or equity to tax foreclosure. So in Tyler, a 94-year-old woman had accrued arrears of $15,000 in late taxes and penalties. The county foreclosed and held a tax sale. The unit sold for $40,000. The county kept the proceeds. The court ruled that keeping the windfall of $25,000 violated the takings clause of the Fifth Amendment. In Ms. Lucas's case, you just heard the home was sold at auction for $45,000. Law New York was able to recover the surplus funds of over $34,000. Since the Tyler decision, Law New York has challenged individual counties that retain excess funds from real property tax foreclosure sales. To give you an example, out of the same office that Ms. Lucas received assistance in Bath, New York, our Bath office filed a hybrid Article 78 and 1983 complaint challenging a county's retention of the surplus funds after a tax foreclosure sale. This complaint was the first case in the state to challenge a county's retention of tax foreclosure surplus. Citing Tyler, the team argued that the county's retention of surplus funds after selling the foreclosed property at auction constituted a taking without just compensation. The court ruled in that client's favor, ordered the county to return more than $20,000. In addition to this litigation work in these matters, to ensure that the decision in Tyler is fully implemented, legal services staff across the state need to engage in coordination and education with our local counties, the communities that we serve, and the agencies that serve community members who may be affected. Advocates also need to take into account the other needs of our clients while we work to resolve their legal issue. So while Ms. Lucas was looking to relocate to new housing, an eviction proceeding was filed. Law New York staff were able to intervene, negotiate a lengthy adjournment, giving her time to relocate. That eviction was ultimately withdrawn. This case also highlights challenges that are faced by legal service practitioners. A challenge often faced by our organizations is having enough resources to handle complex or litigated legal cases. Complex cases frequently address novel or significant legal questions that can set up important precedents. These cases help shape and develop legal principles and standards, influencing future legal interpretations and applications. The lack of specialized expertise to handle complex or litigated matters is particularly acute in our rural service areas. Rural areas have fewer attorneys. Those who are available may have limited specializations. Law New York is a member of the Legal Services Coalition, and I would be remiss if I didn't mention that non-competitive salaries for civil legal services staff have also led to an inability to recruit and retain a sufficient number of talented attorneys and other legal professionals. This shortage can make it difficult for residents to obtain legal representation or advice, and for legal services agencies to maintain the expertise necessary to handle complicated legal matters. Your support is vital and necessary, not just for the work we've done with Ms. Lucas and many clients similarly situated, but it's vital for the future of our programs and for the future of our client communities. And I want you to know in closing that your resources have had a profound impact on clients like Ms. Lucas. They've also had an incredible impact on practitioners that are able to devote their time, their energy, their expertise to contributing to the public good. Thank you so much for the time to give remarks today.
Thank you, Ms. O'Brien, and thank you for everything you've been doing. We have questions from the panel.
Just one, Judge. Ms. O'Brien, good afternoon. I'm just curious, what was the county's legal justification for holding back surplus monies from Ms. Lucas?
So prior to Tyler, Tyler is really what made this decision. And our ability to help Ms. Lucas was aided by having the Tyler decision. So the role that Law New York and civil legal services practitioners played after Tyler is really also educating our counties. Now, in this case, our staff was able to file a motion. The county ultimately consented. And so when a decision that sets a precedent occurs, a large role that our organizations play is in that education and implementation of those decisions.
So prior to Tyler, then what was the justification, if at all any, of withholding surplus money? So they just withheld it and hoped for the better? I try to understand what the mindset was. If you
Well, I think us looking at it now, it seems like unfair in taking of those surplus funds, but at the time, without a legal decision, there was no other precedent or other ruling for the county to say that that wasn't the appropriate decision.
And Dominic, to answer your question a little bit, I recall it was probably in the late spring, early summer of 2023, I got a letter from an upstate New York judge, whom I didn't know, but who said that the general practice had been that counties would keep the money, but he'd been very vigilant about ordering them that they had to return the surplus, and he was urging me to sort of either implement a court rule and it just at about I know it must have been just before the Tyler decision, because as I was looking into it, the Supreme Court decided Tyler.
The fact that it's labeled a surplus seems to be counterintuitive, right?
Right. But, at least it does seem as if for that particular issue, the U.S. Supreme Court has given you a pretty good weapon.
Absolutely. And, oftentimes, frankly, even in the face of an issue, if it appears unfair, without the litigation that goes into making those decisions, we may not have that tool to seek justice or seek access to justice for our client communities.
Well, thank you both very much. Really appreciate your time and everything you've been doing.
Thank you.
And Ms. Lucas, best wishes.
Thank you so much, Your Honor.
We were going to hear next from Colleen Stevens and Keisha Williams of Neighborhood Legal Services. Ms. Stevens is unable to present today, but we do have a written statement which we'll put in the record, as well as the statement of Keisha Williams from Neighborhood Legal Services. So we're going to turn next to Tracy Luter, who is a client of the Volunteer Lawyers Project of Central New York, and Sal Curran, who is the Executive Director of the Volunteer Lawyers Project of Central New York. We'll take a minute to get them on the screen.
Are we good to go?
We're almost good to go. We've got Ms. Luter on. We're waiting for Ms. Curran.
I'm here.
Oh, there you are. I was looking for two different screens, but you're just off stage there, but great. Glad to know you're there.
Okay, let me get us started then. Ready to go? Yeah, okay.
Good afternoon, everybody. My name is Tracy Luter, and I am a former client of the Volunteer Lawyers Project of Central New York. I was born and lived the majority of my life here in Syracuse, and most of my adult life struggled with housing stability. Husband and I currently lost our previous housing and most of our housing due to serious code violations, whether it be mold, mice infestations, leaking roofs, leaking basements. And we have landlords that have refused to make the repairs despite being coded, being cited by codes, in which time that caused my condition to become sicker and sicker and eventually causing severe pulmonary issues and congestive heart failures. Once that happened, we had to move out, just leaving our stuff there, staying with friends, family, and then eventually to a hotel. Finally, August of 2023, we found our current apartment, which seemed great at first from the outside. The neighborhood's beautiful, yard's good, the inside, everything looked great. But we quickly learned how erratic and unstable mentally our landlord had become or would become. In late October of last year, we began smelling gas in the apartment, which caused me to call National Grid, at which time they had come out, red tagged the furnace and turned off the gas flow in our house because the gas was seeping into the apartment. That caused the landlord to become extremely furious with me, banging on my door, threatening to attack me with a shovel because I had not called her first. She was stated that she needed to have a professional come and fix the furnace, which she had not done. And that caused me to call National Grid once again, in which time they red tagged it, but they hadn't turned off the gas flow. And because I had to call them again, she started refusing to take our portion of the rent. Well, our rent is subsidized through a agency here, Liberty Resources, due to my husband's disabilities. And so our portion was $281, in which she tried to take me to court for non-payment of. I reached out to Volunteer Lawyers Project, who then represented me in that case, and had the case eventually became thrown out because it was stated that she could not refuse to take the rent. Once that happened, she then began doing other erratic and unhealthy things to us, and tried to get us evicted once again, because we were still at this point calling code enforcement for code violations and National Grid once again. So she tried to have us evicted, now not because of non-payment, not just because she wanted us out. And once I reached out to Volunteer Lawyers Project again, who represented us, is they had this particular case thrown out because we were able to prove that what she was doing was retaliating against us because we were asserting our right to have safe housing and, habitability standards. And retaliation, I never knew that that was a defense that you could actually have until I worked with my attorney here through the Volunteer Lawyers Project. And through that, learned my rights, how to stand up against the landlord, and how to still be housed in, my apartment, although she's continuously harassing us. It does take a while to find housing here in the Syracuse area that is affordable and habitable. Most of the apartments that are inhabitable or they're overpriced. And through Volunteer Lawyers Project and their program, their landlord tenant program, it has taught me how to fight, how to get a backbone, and it allows me to advocate not only for myself, excuse me, I swore I wasn't going to, but this is so personal to me because I watch what landlords do and they get away with it. And there are other tenants that don't know, they get intimidated by their landlords and they don't fight back. So with my work with Volunteer Lawyers Project, it's allowed me to be able to fight for myself and to help others advocate for themselves, which I continuously do on a regular basis. So it's, I either give them the information that's been shared with me or I send them down here to Volunteer Lawyers Project because I now know what resources are available to me and to them. So this advocacy is very personal to me because it affects not only me, but my community as well. And my community means everything to me. So I want to thank you for your time and your support of programs like Volunteer Lawyers Project of Central New York and everywhere else, because it's much needed. Everyone have a blessed day. Thank you.
Thank you very much for sharing that with us. There's pretty good data that half of the people in your situation don't even try to get legal help because they don't know that it might be available. I mean, those who ask oftentimes can't find it, but half of people wouldn't even have known. So I'm curious how you found out about the Volunteer Lawyers Project.
I'm a researcher, so I'm going to dig. And fortunately for myself, there is an employee here at Volunteer Lawyers Project whom I had worked with previously through one of the shelters when I had to stay in a shelter. She was a case manager through another program here in Syracuse called Hill. And then I found out she was the intake worker here for the tenant landlord. And so she was very instrumental in getting me set up here with the Volunteer Lawyers Project. So she knew me personally from having been a previous case manager of mine to getting me lined up here.
So kind of just, fortuitous in a way, right? Just that connection.
And it is, and I'm about paying it forward. So that's why things like this are very important to me, whether it's here, a food pantry, I know about, it could be anything. The program that the intake worker has shared with me, I'm about paying it forward. So I don't keep that information to myself. I would like others to know what is out there.
That's great. We have questions from the panel at all? No? Ms. Curran, we're over to you.
All right, thank you so much. Thank you, Tracy, for those really powerful remarks. I think, Chief Judge, when you mention that it's fortuitous, I would just posit that it's not just fortuitous. Organizations like mine intentionally try to hire folks from the community that are deeply connected who will help tenants trust us, So, okay, going to my prepared remarks. Good afternoon. I am Sal Curran, the Executive Director of the Volunteer Lawyers Project of Central New York. I am a member of the Permanent Commission on Access to Justice and a board member of the New York Legal Services Coalition. And first, I want to thank you, Chief Judge Rowan D. Wilson, and also this entire honorable panel of leaders from our legal community for the opportunity to address you today and for your ongoing commitment to improving access to justice. VLP is a legal aid program in Central New York whose mission is to provide access to justice by engaging the legal community in service to those in need. Our staff and panel of over 700 volunteers serve more than 4,000 clients throughout upstate New York every year, benefiting over 10,000 community members. Again, I want to thank Tracy for her remarks. Tracy has demonstrated tremendous strength in fighting for her right to safe housing, even when doing so put her at risk of losing that housing. Sadly, Tracy's experience is too common. Landlords regularly try to evict tenants who complain about habitability concerns that put the health of their family at risk, like infestations, sewage in the basement, and more. Like for Tracy, these habitability issues can lead to health issues as serious as congestive heart failure, resulting in ICU stays. Tenants have fought long and hard to get laws passed that protect their right to safe housing free from landlord retaliation, harassment, and illegal lockouts. But these laws have little effect without a lawyer to defend the tenant. In some senses, Tracy was actually lucky because she lives in the city of Syracuse, where there are more attorneys available to represent tenants. Had Tracy lived in one of the 1,300 towns and villages in upstate New York that have justice courts, she almost certainly would not have found an attorney to represent her. Just in Central New York, there are over 300 justice courts that collectively hear thousands of eviction matters, but there are only just over 24 legal aid attorneys to represent tenants in this region. Pro bono can't fill the gaps. Most rural counties do not have enough attorneys to do the necessary court-appointed work in criminal and family matters, let alone to do pro bono work in eviction. Most tenants have no attorneys in eviction, and evictions have terrible consequences. They're tied to long-term housing instability, job loss, negative health consequences, education loss, and more. In Central New York, where rents have been increasing by 20% or more year after year for the past few years, tenants who are evicted are no longer able to find housing that they can afford, which has led to the highest rates of homelessness, and especially family homelessness, that have ever been recorded. With new protections in place, such as good cause eviction, it's more critical than ever that the New York courts support efforts to close the justice gap by ensuring that all tenants have access to legal representation in eviction proceedings, and that those who are entitled to legal representation, such as those in New York City and Westchester, are given time to attain such counsel before the matter proceeds. And secondly, I wish to speak to the need to address the low wages paid to staff at legal aid organizations, which negatively affects recruitment and retention. My colleagues, Kristen Brown and Adrian Holder, already spoke at length about the findings of the surveys and the effects that wage gap has on recruitment and retention. When I completed these surveys, at first I thought, oh, we're not doing so bad because we have brought up our starting wages. But then as I dug in deeper, I realized that by 10 years into practicing, my attorneys are being paid 50% less than their government counterparts. And that doesn't even take into account the long-term pension. I suspect that this may be the case for other organizations. This has resulted in it taking 6 months or more to fill a vacant position in my organization, putting serious strain on other staff filling in, and ultimately resulting in less clients being served during the vacancy and onboarding process. I myself, as executive director, had to fill in representing clients in eviction court for 6 months earlier this year, and I was the one that represented Tracy and her husband. The problem is that this wage disparity is built into our funding structure and gets worse every year. Most sources of funding have not increased despite the real cost of operating our organization and the real cost of living drastically increasing. When additional money is made available, we're expected to increase the number of clients that we serve proportionately, leaving no room to increase salaries or reduce caseloads. To ensure consistent representation for those in need, we need for funding to increase to allow legal aid organizations to provide compensation that's competitive. I want to thank you so much for this opportunity to speak with you on these important matters and for your past and future support, not only for my organization, but for all of our colleague agencies and the civil legal services community throughout the state. Together, I know that we can continue to close the justice gap. Thank you.
Thank you. We do have some questions for you.
Councilor Coran, we have had the opportunity to meet in the context of collaborating on some issue in the past, as I recall. And it's good to see you here today. I did not know, and I think I want to start with congratulations, that over 12 years you built this organization from 2 full-time employees to 30, I think I read, and amazing. What a tremendous job you have done in service for your community.
Thank you so much, Your Honor. It wasn't alone, I assure you.
700 volunteers, that's an awesome management responsibility. So I have a couple of questions. One is the staffing, those 30 positions, how many of them are lawyers and how many of them are functioning in other ways. But the other thing that we've heard a lot about today is the use of virtual proceedings, and specifically in the far-flung rural town and justice courts, the fact that virtual proceedings are not being utilized in those courts. And we've heard some pro and con, but it's such an irony that one of the perennial justifications of town and village courts' existence is that they are close to the community. And yet, conversely, what we've been hearing for much of the day is that makes it exceptionally difficult to provide legal representation in those courts. So I know that was a lot, but so first, congratulations. How does the staffing break down? And then finally, your view, if you could, on one approach being to enhance virtual access in the town and village courts.
Absolutely. So first, with regard to the attorneys and non-attorneys, I believe we have 14 attorneys, including myself, and the remainder are non-attorneys. In our organization, we're what you might call a hybrid organization, where we do have some attorneys in certain programs providing some direct legal services, mainly in immigration. But in the vast majority of the rest of our programming, the attorneys are very experienced attorneys. We have several that have 20, 30 years of experience. And they're really there to supervise, coach, train, and help along the volunteer attorneys who might not have experience in those areas. So what we try to do is in each program, we have an experienced supervising attorney who's the director of the program. And then we have a pro bono coordinator who's working as the primary interface with the volunteers. And then if we do have direct representation going on, like we do in eviction court as well, we have both pro bono and direct by our staff, then we try to have a legal assistant as well. So it's really a combo. With regard to solving the issue of the outlying counties, I will say we have tried extensively to recruit and retain volunteer attorneys in the outside counties. Syracuse, we're really lucky because not only do we have an outstanding law school in Syracuse University, but we have many of the large statewide firms and even local firms have staffing here. And so we have tried to have services in Cayuga, Oswego, Jefferson, and in all of the instances, we've only been able to recruit just a handful of volunteers to staff programs there, which has been really frustrating. And so I've attended meetings with local county bar associations over the years to talk with them about this. And over again, they have expressed that there's just an extreme lack of volunteers in those regions, lack of attorneys, right? Everybody is already working full tilt. And if they have any extra time, they're going to do court appointed at that point, And so I really do think that in order to reach a point of being able to provide right to counsel and eviction proceedings, which I'm a very strong proponent for, we will have to end up doing virtual appearances. And I have spoken at length with my colleagues out in Erie County, where they have done a hub court during COVID. They did the hub court so that they
can consolidate most of the justice court proceedings. And my understanding is they had really great success with that. So I would very much be in favor of a hub court. I do think that the remarks that were made by Judge, I believe it was Judge Calvo Torres who made the remarks about how do we go about making it so that the clients can still access court. We do have a great model here in Onondaga County of the virtual court access program that our law library has really taken over. And so in addition to having kiosks at the justice courts, I would actually say that the kiosks might be better located at the libraries, which have more hours, because the justice courts in most towns have very, very limited hours and extraordinarily limited staffing. And doing virtual court appearances does require the assistance of somebody else to get you connected. If you need to scan any documents or anything like that, they can scan them. And I have found that the county libraries have been the best partners for that. So I think that there's a couple of different models. I know our virtual court access program is also looked at, has also placed kiosks at community-based organizations and faith-based organizations, both of which are also very good solutions. But again, because of the hours and the staffing, it can be a little difficult. So,
Thank you.
We have another question for you.
Good afternoon, Mr. Kern. Your client mentioned that the way she found the VLP was through her own research. I served on the VLP at the Brooklyn Bar for a whole bunch of years. And what we did there, and I'm questioning whether you can do it where you are, we had signage in the courthouse. Are you able to have signage in the courthouse so that people, when they go and they see, they can call you and can avoid, having to miss you? Is there a way of doing that?
Thank you, Bar President, and thank you for your leadership and all of the volunteer work you're doing with the Bar Association, not only this year, but over the years. Yes, our city court is very good at letting unrepresented tenants know about the availability of legal representation, and actually hands out a handout with all the organizations listed if somebody appears at court unrepresented at the first appearance. That is not necessarily the case in all of the town and village courts, nor is it possible for attorneys to be present, of course, at all the town and village courts. And even in the city of Syracuse, right now we are far from being able to provide representation to all tenants that appear.
Thank you.
Yeah, I will say that the court clerks across the board are the best promoters of civil legal aid. I would say across the state, the court clerks are really remarkable at letting people know about the availability of services in all of our programs.
Thank you very much, and Ms. Luter, thank you as well. Thanks for spending the time with us.
Thank you very much, Your Honor.
We are next going to hear from Ashley Garcia, who is a client of the Legal Project, and Carla Brogok, if I pronounced her name correctly, who is the legal director there. The floor is yours. We'd love to hear from you.
Okay. Judges go?
Yes.
Okay. On December 21st, 2023, I asked the family court to protect me and my children from my husband. We have been married for 11 years. We have 2 children, now ages 10 and 11, and we own a home. Within that home, my husband was controlling, mentally unstable, and prone to violence, but he kept that abuse inside our home. Since 2019, my husband has hit me, raped me, threatened me with a metal baseball bat, threatened to cut me with a box cutter, swipe it at me, strangle me until I briefly passed out. He frequently threatened to kill himself, cut himself, or hurt himself. He hurt our pets, and towards the end, our children, and that's when I started looking for help. The Legal Project explained how I could file a family offense petition and get an order of protection, and it worked. The court immediately issued a temporary order of protection, removing my husband from our home and keeping him away from me and the children. For the first time in years, I felt safe within my home, but unfortunately, it was temporary. I returned to court about 2 weeks later. My husband was assigned a public defender, and my children were also assigned an attorney assigned by the court. I was alone, and as a teacher, I make too much money to qualify for the court to assign an attorney, but not nearly enough money to hire one. I also did not know that I needed an attorney. I thought that it would be as simple as telling my part of the story, but it was not. My husband's attorney insisted that my husband would be homeless and my children would miss him, and no one discussed my husband's violent behavior. I barely got the chance to speak and ultimately did not know what to say. The family court allowed my husband to return to our home after a mere 2 weeks. The court reduced my order of protection from a stay-away order to a no illegal contact order. Essentially, the family court ordered my husband not to commit any new crimes against me or the children. I called the legal project again, and Attorney Weinhold was assigned to represent me in court. At that point, my husband had been home for about a week without violence. I understood that the court might not remove him until he committed a new crime, but I was afraid of experiencing that crime. Attorney Weinhold began gathering evidence while I began to look for apartments for me and the children. It was very unfair that we would have to leave our home to escape my husband's violence. I knew that I would not be able to find an affordable apartment that allowed us to take our dogs and cats, but I feared that if I left the pets at home under my husband's care, he would hurt them. I also knew that I would not be able to find an affordable apartment in my children's school district, but we could not continue to live with my husband, waiting until the day that he had a relapse and went back into his violent behavior. My third court date, the first with Attorney Weinhold, was just a few weeks later, and she warned me beforehand that she probably could not get my husband removed again, since he had not yet violated the no illegal contact order. But then she did exactly that. Attorney Weinhold had listened carefully to me and worked hard to gather supporting evidence, so she was able to show the judge that it was too dangerous for my husband to live in our home, even though he had successfully abstained from violence for a few short weeks. And just like that, I began to feel safe again in my home. My family court case technically did not resolve until mid-April, where I gained sole custody of my children and my final order of protection. But Attorney Weinhold was with me for each step of the way, and I was able to get the help that I needed to keep myself and my children safe, because I had access to an attorney with the right expertise who was committed to helping me.
Thank you. So, the circumstances you described are ones that are too familiar and pose a real problem, because in some ways the people who the system is the least capable of helping are people who make enough money that they don't qualify for help, but they don't make enough money that they can actually afford to hire lawyers, and particularly in situations where there is violence or threat of violence or criminal behavior involved. You're really caught in this sort of limbo where we don't yet have good resources other than essentially legal services providers who take this on themselves and really don't have the resources or staff to help everybody who's in those situations. So you're fortunate, really fortunate, but there are many people, I think, who are in your situation where the systems writ large have failed, which is, I think, a huge problem. We may have some questions from the panel for you. We certainly have one here from Justice LaSalle.
Thank you so much, Chief. Ms. Garcia, let me initially just say how happy I think I speak for that you were able to obtain the help that you needed in this particular matter. From what you described, you were a victim of numerous crimes during a long period of time. So initially you have, I'm just feel very fortunate you've been able to remove yourself from that and your children from that situation. I guess the question that I have for you, and I know that you can really only speak for yourself, but as a victim of domestic violence, what are we missing as far as the situation you were in regarding obtaining these services? You were able to do it, right? But what are we, as a court system perhaps, or as a society, what are we missing? What was missed perhaps in your situation that prevented you from earlier on perhaps obtaining this help? Because I know you say it goes back to 2019, so I'm just really curious that perhaps your testimony today can help us and help other victims of domestic abuse?
Back in 2019, I didn't have the resources. Like, there was a situation back in 2020 where I did go to get an order of protection, but just due to fear, I wasn't able to finish out and continue with the order of protection. Even though like within a week or two, he was back to like his violent behavior. And then this time around, back in 2023, or actually in 2024, because it was in January, I sat there kind of by myself. I didn't have the resources there to have an attorney by my side, where the court assigned him immediately an attorney, and like the attorney.
I'm sorry, Ms. Garcia. So he had counsel as the criminal
Yes.
defendant.
Yes.
You, the victim, had no counsel. Is that
No.
what happened here?
Yes.
Interesting. Thank you.
He was assigned a public defender. The children were also assigned an attorney, and both attorneys, they both made the story, they completely disregarded all of the violent behavior that was in my petition, and stood with the fact that he was going to be homeless, and pretty much I was by myself, and I couldn't, and even as I was trying to explain the situation to them, they just were not listening to it. He just had like, it was me against two qualified lawyers, pretty much.
I'm sorry you had to go through that, and thank you for answering my question.
You're welcome.
Bogak, I think we can hear from you.
All right. Good afternoon. I'd like to thank you for the opportunity to speak on behalf of the attorneys and clients of my organization, as well as the wider New York Civil Legal Services community. My name is Carla Brogach, and I'm the legal director at The Legal Project, a private civil legal services agency that has been representing residents of the Greater Capital Region for nearly 30 years. The Legal Project works to make the legal system more accessible for those in need, to increase the legal community's involvement in pro bono work, and to serve as a resource on important legal issues. Our clients do not pay for our services. Rather, we are funded by a combination of state grants, federal grants, and private donations. Our state grants include vital JCLS funding, for which we are extremely grateful. Our aim is, and always has been, to make legal representation more accessible in a practical way by taking into account a person's ability to afford legal assistance. For a large portion of New York residents, having a lawyer is out of reach, no matter how dire the circumstances. Even though legal services can be essential to obtaining and maintaining what an individual or family may be entitled to under the law, when you have bills to pay and money is tight, attorney fees are never going to come before rent, food, utilities, or medical costs. While increasing the number of volunteer attorneys and expanding the use of technology are excellent suggestions for increasing these services, the reality is that the only way to reliably make civil legal services available to New Yorkers is to adequately and sustainably fund these services. Our civil justice system has ways to ensure New Yorkers have access to help maintain the essentials of life. But without legal representation from qualified, experienced attorneys, these protections remain out of reach and are rendered essentially useless. We have created a justice system that depends on the idea that both sides of a dispute have the expertise to argue their case before an impartial finder of fact. By not adequately funding civil legal services, we perpetuate an unjust system where only wealthy litigants receive the protection of the law. This is not acceptable. It is also imperative to fund competitive and sustainable compensation for legal services attorneys. Our attorneys earn significantly less, including health benefits and retirement contributions, than their government and private counterparts, though their expertise and experience are identical. Recent data show that in some areas of New York, civil legal services attorneys with 10 years of experience earn up to 75% less than assistant AGs with the same amount of experience. We rely on the willingness and ability of individuals who have spent 7 years pursuing a degree to sacrifice their earning potential and the financial security of their own families to close the access to justice gap within this state. This is neither realistic nor sustainable. The pay disparity also makes it extremely difficult for civil legal services agencies to recruit and retain attorneys. Experienced attorneys will often be forced by economic factors to leave civil legal services so that they can afford to purchase a home and raise a family. Funding for civil legal services needs to take into account the ability of civil legal services to compete in a job market with the better salaries and benefits offered by the state and private sector. If we cannot hire attorneys to do the work, if we cannot retain experienced attorneys, if we cannot compete as employers, then we cannot provide the legal services that are necessary for our civil justice system to function in a fair and equitable manner. It is not acceptable to perpetuate a civil justice system that favors individuals represented by an attorney, but then makes access to said attorneys a financially out of reach or impossible idea. It is not sustainable to rely on the idealism and naivete of young attorneys fresh out of school who do not understand the long-term economic impact of their decision to pursue a career in civil legal services. The reality is that there are thousands of New Yorkers who face civil cases involving the essentials of life who will not be able to obtain the legal assistance that they need, and whose lives will therefore be forever altered. Adequate, sustainable, and forward-thinking funding for civil legal services is essential for the justice system in New York to remain fair and equitable. Such funding must ensure the continued existence of these services at a sustainable level that respects the humanity of both the clients seeking these services and the attorneys and support staff providing them. We are all New Yorkers, and we all deserve respect regardless of our financial situations. Thank you again for the opportunity to speak on this vital topic.
Thank you, Ms. Bogosh. We may have some questions for you.
Yes, thank you.
I do have one at least, which is, I assume you get more requests for help than you can handle. Is that fair?
That is absolutely fair, Your Honor. We do get more requests in all of our departments than we can handle in terms of our capacity. And we have a system where we try to triage cases based on what other options a client might have, how dire or dangerous the situation might be. In the case of domestic violence, we will look at lethality factors, but we do turn people away. And I think that's true across the state.
Yeah, I mean, you answered, my follow-up was going to be how you sort them out, but I think you answered that, which is you triage them, which to me implies there's a bunch of good cases that you can't take.
Yes.
Well, thank you very much both for your time and your information and observations, and we understand the problems and are working hard to try and fix them, and I think you've given us some good ammunition. So thank you.
Thank you so much.
And then our final presenters for the day are Erin Nakova-Watts, who's a client of the New York Legal Assistance Group, and Lisa Rivera, who's the president and CEO of the New York Legal Assistance Group. We'll get them on the screen in a minute. Good afternoon. Can you hear us okay?
Yes, good afternoon.
Ms. Watts and Ms. Rivera?
Hello. Hello.
I think we're eager to hear from Ms. Watts first and then Ms. Rivera.
Hello, my name is Erin Nakova-Watts, and I'm here to talk about my experience getting a legal name change and how the support I got from NILAG helped make this possible. My name is gender neutral, but when I was born, it was spelled the traditionally masculine way, 2 A's, R-O-N. When I was 15, I began identifying as non-binary, wearing makeup and feminine clothing. I created the own spelling of my name using an A from the masculine spelling, E from the feminine spelling, and I added a Y to make it my own. Growing up, my mom and I didn't get along. She had a lot of mental health struggles. We moved around a lot. She's from Alabama and very conservative, so she wasn't supportive of me and how I expressed my gender. As a result, I've been on my own since I was 16 years old, and I had to move in with my friend's family when I was in high school. I'm a very self-motivated person. Even though I was on my own, I still managed to graduate from high school and receive financial aid to attend ASU. It was in my sophomore year of college that I realized I am a woman. I ended up taking time off from college. I was dealing with significant health issues and also having issues with my roommates. I got a job as a night auditor at a hotel. I put my studies on hold and I moved back in with my friend's family. This time, however, my friend's father did not approve of me living as the woman I am, so I had to leave. It was time for me to start over. A friend said I could stay with her here in New York City. This seemed like a great opportunity for me to have a fresh start, find community, and pursue my interest in fashion and journalism. But the masculine spelling of my name was becoming more of a problem for me as I lived my life as the woman I am. Sometimes my coworkers would see me, see how my name was spelled on my records and look at me funny or ask me about it. I was afraid of how they would respond if they knew. I would laugh it off and make excuses like my mom had a sense of humor. I knew I needed to change my name legally, but I was not sure how to do it. I researched getting a name change while I was still in Arizona, but there was a lot of stuff about publication and I didn't understand it. When I moved to New York, I was also confused. Moving to New York, I was also confused. There's so many different courts in New York City and the whole process is very intimidating. I started up saving up money for the fees and also to pay someone to help me. I moved to New York in October of 2023. I got a job and stayed with my friend for a few months. I ended up losing my job and I had to move into a shelter. I wanted to move forward with the name change, but life got in the way. I got my medical care through the HEAT program at SUNY Downstate, and HEAT stands for Health and Education Alternative for Teens. It's a program that provides comprehensive health care, including gender-affirming care. I was there one day for my hormone therapy appointment when I saw a flyer for an information session on getting a legal name change, which was being offered in partnership with NILAG's LGBTQ law unit. I knew this exactly what I needed, so I copied down the list of documents to bring, and I made a plan to attend the event. It took a huge weight off me because I felt like I was finally on track to getting this done. At the event, I met my attorney, Adina Wayne, and the law students who were volunteering to help. Adina explained to everyone how the process works and what to expect. She told us we might be eligible to waive the court fees and that NILAG would assist us free of charge. Then I met with Gabby, a law student volunteer, who talked to me about why I wanted a name change, took down all my information, asked me questions, and reviewed my documents. Gabby and Adina prepared the court papers, and I went to the NILAG office to review and sign them. I was thrilled when I got a call about a month later saying the judge had signed the orders and my name change was complete. I returned to NILAG to pick up my name change orders and learned about the next steps for updating all of my identity documents. This is a major step in affirming my gender. Now I feel safer, I feel more capable of blending in, I feel so much less anxiety, not worried all the time about what people are thinking and being afraid of how they might react. Now I feel more confident applying for jobs and making plans to return to college. I just moved out of the shelter and got a lease with my correct spelling of my name. I feel like my life is beginning and I'm ready to tackle my 5-year plan. I'm grateful that my lawyers were willing to come to the HEAT program. With the pressures of day-to-day survival, I don't know when I would have been able to accomplish this on my own. Thank you for this opportunity to tell my story and for your support of free legal services.
Thank you. That is an amazing story. And I guess I have two quick reactions to listening to you. One, well, maybe three. One is how articulate you are. Two is it's almost unfathomable to me how much prejudice you've had to deal with in your life. And you're still young, and hopefully things will get better. But it's, all of us had to deal with some, and it's sort of staggering. And the third is earlier on, I'm not sure if you were tuned in or not, I made a serious but also slightly humorous remark about not being a New Yorker originally, but being, in New York now, and New York is the greatest place, I think, and I was referring to the city, but in the world. And your story kind of reaffirms that a bit, because you came here and things have worked out, and, I'm thrilled. And I don't know if we have some questions or observations or anything from the panel. Nope. We're on this issue. We had a meeting of the Administrative Board of the Courts today and adopted something that will help people in your situation going forward too. So, Ms. Rivera?
Hello. Good afternoon, and thank you to Chief Judge Wilson, Chief Administrative Judge Zayas, and all the presiding judges for gathering us here today. I'm Lisa Rivera, and I'm the President and CEO of the New York Legal Assistance Group, otherwise known as NYLAG. NYLAG uses the power of the law to help New Yorkers in need combat social, racial, and economic injustice. We address emerging and urgent legal needs with comprehensive free legal services, impact litigation, policy advocacy, financial counseling, and community education. The work that organizations like NYLAG do to promote access to justice empowers individuals and families, uplifting entire communities with legal services as we also pursue systemic solutions. We just had the immense honor of hearing from Erin, whose story captures the strength and resilience that brought her to New York and eventually to work with us at NYLAG. Her story and the others that we heard today also capture the real importance of our work, which we can only sustain and grow with increased funding from the Judiciary Civil Legal Services grants that we receive. NYLAG's LGBTQ Law Unit works to defend and expand the rights of New Yorkers' LGBTQ community and offers legal advice and representation in a wide variety of poverty-related civil legal matters, such as employment, housing discriminations, public assistance, immigration, name and gender marker changes, and family law. Each year, the LGBTQ Law Project, or unit, represents hundreds of transgender, gender nonconforming, and non-binary New Yorkers seeking name changes. The importance of identity documents that properly reflect transgender, gender nonconforming, and non-binary New Yorkers for who they are can't be overstated. As we just heard from Erin, accurate documents are instrumental for her health, her future planning, and her stability. As you heard, she now can pursue her 5-year plan. We also heard from her about the arduous journey to acquire these accurate documents, namely in attempting to navigate New York courts and its rules. All these systems are complicated to navigate. I think many of us here today will readily admit, even as attorneys, we often have a hard time making sense of the many hoops that our clients have to jump through just to accomplish what should be a simple task. So for people who aren't attorneys or an advocate and who are in crisis with already limited access to resources and support or limited English proficiency, it's even more overwhelming to say the least. Ultimately, that's why NYLAG and our fellow legal services organizations exist. People shouldn't need an attorney to meet their basic needs, to live fully as their authentic selves, to not only survive, but thrive in their lives beyond whatever brought them our way. But until that's an actual reality, we're here to do the work with our clients to help them achieve their goals. Yes, our systems are actually really complicated, but justice is simple to understand. It's all we want and what we deserve. Justice for Erin and for thousands of New Yorkers in similar situation is being who they are, having access to affirming healthcare, being safe, having a secure roof over their head, and having every opportunity to build a life without the obstacles that come with inaccurate identification documents. Justice, again, for Erin and for so many others, is finding an advocate that can work with them to get them there in the spaces where they already are, like the HEAT program that she referenced earlier. At the core of these efforts stand our advocates, our dedicated paralegals, attorneys, case managers, our dedicated employees who need to be able to make ends meet so they can show up for their colleagues and their clients every single day in these really difficult circumstances. Long-term continued investment in legal services is absolutely critical to meet the current and future needs of individuals and families in New York. Legal services providers need funding that meet our costs and supports our ability to provide innovative, trauma-informed, and culturally responsive services to continue to assist individuals in navigating the complexities of various systems our clients have to face when they attempt to achieve justice. NYLAG's ability to respond to the ever-increasing need in the community, to recruit and retain staff, and to pay our advocates competitive and fair wages is significantly challenged because of depressed wages in our market. Our work about expanding access to justice, and this is not only possible without increased funding, so that we can raise salaries for the people on the ground doing our work that our community would otherwise go out without and desperately need. It is essential for our advocates doing this life-changing work to receive this funding so they can afford to live here, so their salaries can reflect their experience and their dedication to making New York more equitable for all. I want want to thank again Chief Judge Wilson and Chief Administration Judge Zayas and the Office of Court Administration for your ongoing support in funding vital civil legal services. We're looking forward to continuing our work together to meet the needs of every New Yorker with high-quality civil legal services. Thank you.
Thank you. Questions from the panel?
Not so much a question, but a statement about legal services and the great work and the great breadth of work. We've heard today about the importance of housing, of the evictions that take place, of family court, of abuses that take place, and about identity issues. And it all leads to respect, and respect that clients deserve, and the representation that they deserve, and the wages that those who do this difficult and important work deserve. So thank you very much, along with the other presenters who have made that, so the importance of equal, wages for civil service attorneys who have made that so clear and so it's so important. Thank you.
Thank you, Judge Renwick. I will say that, NILAG and all the other organizations that testified today, that's how we want to lead. Many of our clients often feel the lack of respect and the lack of dignity as they navigate the systems they must in order to be safe in their home, in order to be able to have a roof over their head, to be able to access benefits. And us providing services that bring back that dignity is crucial. And us being able to take the time, learn their stories, understand how they want us to advocate for them and lead them to be able to use their voice so they can also advocate for themselves is really why we all exist at the end of the day. And I so appreciate your remarks.
Thank you. That actually ties in very well to where we started, which is that people need to have faith in the system. And there are all sorts of consequences when they don't. And, we've known that for a long time, and we're not doing as good a job as we could. And we need to do better. So thank you both very much.
Thank you.
And good luck, Ms. Watts. Thank you. Well, that concludes our hearing for this year. We have a lot of information, a lot of things to do. I appreciate all of you who stuck through this in person and online. Thank you very much, and we'll do it again next year, and we'll maybe have a little bit happier news, too. Thank you.